we've already done a little bit of the Sarah Boone sidebars about a week and a half ago. If you guys haven't watched it yet, check out in the live stream. But I will put a video together for you guys if you guys want to take a look at it in the future. So we have all the sidebars together. So far in the Sarah Boone sidebars, we've covered the jury voir dire portion of it, which I just thought it was interesting to see reasons why a jury might be dismissed from being part of jury service. And it's kind of interesting to see, you know, the conversation happening behind the scenes, because I haven't really seen any of this before. Furthermore, we are reading more sidebar stuff as the trial is starting to begin in the Sarah Boone case. Now, Sarah Boone has already had her trial last year, 2024. I think it was in October that it started. Man, time flies. That's like more than half a year ago. We're going to start getting to more of the trial stuff, but I think they are still doing jury voir dire. Where we left off last time was the part where they were having a sidebar in regards to Brian Boone, Sarah Boone's ex-husband. Now, during this time, I think they were separated for a couple of years, and they had a marital agreement that Brian Boone was going to give child support and alimony to Sarah Boone, because Sarah Boone was not working. I don't think she was working at all. I think her full-time day job was just drinking and just hanging at the bars and getting into fights with people, but and doing arts and crafts. Can't forget about the arts and crafts now. So Sarah Boone, wasn't working, but she did have partial custody of their son. And I think their son was, I forgot. Was the son maybe in middle school around this time? Maybe like around 11, 12 years old. I don't remember, but if you guys do, feel free to just drop it in the chat. But the part that they are in sidebar right now is where we're discussing Brian Boone and Mr. Owens, Sarah Boone's attorney, saying that, well, Brian Boone is considered an adverse witness and a hostile witness. Because remember, we're like, are they going to call Brian Boone to the stand? Is Brian Boone going to be able to testify? They didn't. We never got to hear from Brian Boone, which I think is okay. But we got to see his body cam footage, though, when he was talking about Sarah Boone and how he had to deal with her fights with her and George, and he would have to come over and like she would like summon him like he was like a fucking white knight or something like that. But Mr. Owens is saying that, Brian Boone is a hostile, adverse witness because, well, Sarah Boone, she's been in custody for like 4.5 years and he hasn't been paying her alimony. And the state's like, well, it's kind of understandable if someone's incarcerated why you wouldn't want to pay alimony or child support. Kind of weird, right? And so Mr. Owens is like, well, that goes to his credibility, and then now we can use it to impeach him. And they weren't really sure whether or not they were going to call Brian Boone, so that was kind of like a pending thing. But I mean, honestly, if Brian Boone were to testify, he wouldn't really be able to talk about his previous relationship with Sarah Boone anyways, and how her previous bad acts could have contributed to her, potentially killing George and putting him in a suitcase. Pretty much what we hear about Brian Boone would just be, I don't know. I'm not really quite sure what the state was planning on getting out of his testimony, but no one knows. No one called Brian Boone. Hi, Candace. How are you doing today? Hello, Christopher. Hey, Nick. Hey, Moondog. Hello. How's it going? Yeah, I was watching the Celebrate testimony earlier on for the Karen retrial. I was like, yeah, we could start the Sarah Boone stuff. Dude, yes, she turned on the plea agreement. I mean, Owens was trying to get her to accept the plea agreement, and he's like, hey, I'm going to represent just this portion, but I don't plan on representing you for trial. And like, he was trying to get her to accept the plea agreement because I think they offered her was like 15 years, but she's already had 4.5 years time served. And then if she gets out on, I don't know if she would get out on good behavior, to be honest, because, this woman was doing things like stapling her clothes. She was getting arguments with the jail staff, and I don't know, maybe some other stuff. So if she were to get out on good behavior, I heard maybe she could have got out in like, I don't know, 11 or 13. Her sentence would have been reduced from like 15 maybe to like 11, 13 or something, and then she get credit for time served, so maybe it wouldn't be that bad for her. But no, this woman wanted to have her story out there. She wanted to battle all the YouTubers, the media, and she wanted to let the world know that we were all wrong and that she was in fact the victim. And she fought it, and she ended up doing really bad, especially when she testified in the stand. She lied so much, man, so much. But she's sitting in jail for the rest of her life, though. Yeah, very, I guess the term they call it now is delulu, right? So again, the last thing that we covered was them talking about Brian Boone being an adverse or hostile witness per the defense. and, you know, talking about how, well, she hasn't received any alimony or child support from Brian Boone. And it's like, why the fuck would Brian Boone give her alimony or child support? Does that really make sense? All right, y'all. So when we're reading the transcripts, again, the transcripts were released, I think about a couple weeks ago. When I'm reading these transcripts, we're going to have a little fun with it. You know, we're just going to do some little silly voices here and there. And honestly, I think it's the best way to distinguish who the speaker is when I do that. And it makes it more fun for me. So let's do this. Hi, Nerdy. How are you doing today? Hello, hello. They don't have parole or good time in Florida. Oh, they serve 85%. Ah, okay. Thank you. Maybe I remember that. I feel like I remember people saying that before. Okay, so if you serve like 85% of your sentence, I mean, oh, you know what? I think we did do the calculation of that. Yeah. She would have only had to serve like another like 4 or 5 years or something, and then she would have been out. Phew, but do we want Sarah Boone prowling the streets, prowling the bars? Oh, no, thank you. She can rot in there. She can rot in there. Okay. All right. What do we got here? So now we are at the bench. So we're about page 900. Total pages is you guys can't see it, can you? Oh, you can't, but the total page is 2,529. Wait, should I zoom out for you guys? Is this better for you? Maybe this one's better for you. Okay, I haven't zoomed out. No, actually, I feel like you guys can't really. What's better? Why does it cut off so much, actually? Hold on. Let me see if I... Oh, maybe I have to make it smaller? Give me a second. Let me see if I can readjust this. Well, this is for if you guys want to read along with me, but if you don't want to read along, just have me in the background. Y'all can listen. Hold on, let me see if I could try to fill the whole page. What do I normally do? Oh yeah, it cuts off like this. I think I prefer to have it zoomed in though, right? It's gonna cut off a little bit. If I'm reading something and it cuts off, just let me know and I'll try to have it scrolled to the right area. Okay, but I think I normally scroll down. I think we should be fine. Okay, let's do this. Oh no, the Sarah Boone voice is it's hard. Okay, she's like meek and she tries to play like as like quiet. I think Lori Vallow would be pretty funny, but nah, no. Actually, hold on. Do we had any Lori Vallow sidebars? They did. Oh, they did have the Lori Vallow sidebars because whenever Lori Vallow would go into sidebar, they would do the headset thing and like play the white noise or some shit like that. That would be interesting to read. By the way, Lori Vallow is trying to get a new trial. Lori Vallow is she's going to work. All right, y'all. So we are now at the bench, the court. Mr. Owens, have you had an opportunity to converse with Ms. Boone about the potential impeachments of her former husband and what answers may be elicited? Mr. Owens. Again, Mr. Owens is the attorney for Sarah Boone. We're also going to hear from Mr. Henderson and Mr. Beck as well. They are also defense attorneys for Sarah Boone. And then for the state, we have Mr. Cacciatore and Mr. J. All right, I hope I got it, everyone. Mr. Owens, my understanding is that potentially through my cross-examination of her husband, Brian Boone, as it relates to their dissolution of marriage file, that it may come out that she had been in custody for 4.5 years, and it may open the door to the fact. I have talked to her about that. I was going to talk to her about downstairs. Oh, hold on a second. Hold on. I remember they wanted to keep it out from the jury that she was in custody for 4.5 years, but she was the one who brought it up when she was testifying on the stand. And then they went into sidebar. They're like, yeah, we didn't expect her to say that. And then I think Mr. Owens like, yeah, I didn't expect her to say that either. But I don't know if it really matters to the jury she was in custody for 4.5 years. I don't know. Maybe that could be really biased and prejudicial. Okay. Okay, so custody for 4.5 years, it may open to the door to that fact. I have talked to her about that. I was going to talk to her about going downstairs and get confirmation unless you want me to spend about 5 minutes with her. The court. I'd rather do it now because I don't know where Mr. Boone's going to be in the state's case tomorrow, and I'd rather go ahead and do it now. Mr. Owens, I will. The court. You all can head back to the table. Thank you. So this document highlights funky because I don't know. It's the way the PDF is saved or something like that. I couldn't figure out how to get it so it doesn't highlight funny. But it just be like that sometimes. All right, let me go back. This one, yes. That's why it's all, I don't know, it's all blocky like that. I don't know why it's like this. Hey, Tuko, how are you doing today? We up in here. Hello, hello. How are you? The court. Yes, sir. Mr. Owens. While I was coming up the elevator this morning around 8 o'clock or so, I think there was 2 or 3 people going to different floors, but I pushed 12. There was already a couple of people in the elevator. When I got in there with my suitcase and whatnot, but there was a black officer that came in late as it was closing. Said hey to him. Said, "You got a trial today?" Said yes. Said Sarah Boone. He said yes. And I said, "Let's get this thing done." And he nodded. Within just a minute, we start going up and one of the females turned like this and I saw she had a juror badge on. The court. Okay. Mr. Owens. Brunette. I think she had a backpack. The court. Okay. Mr. Owens. And so she heard that comment. The court. Is it one of ours? Mr. Owens. Yes, I believe so. The court. Okay. Mr. Owens. There was no dialogue. There was just the statements I made. The officer just. The court. Okay, well, I'll tell you what. Let's do this. Let's bring our jury panel in. And if it's not her, then there's no issue. If it is, we can approach it. We can address it at the point in time. Does that work for everyone? Mr. Owens. I just felt like I needed to say it. The court. No, I appreciate your candor. Thank you. And if it is her, we'll approach. And maybe if we have to dialogue with her individually, and if we have any impact, we can address at the point in time. Okay, thank you. So at this point, I think they have already done opening statements. Maybe. I think trial's already started and the state is presenting. I believe so. The court. All right, we're at the bench again. Mr. James, or Mr. Owens. Mr. Owens. I don't believe she's in the group, but I'm not positive. Okay, all right. Mr. Owens. I don't know if you need to ask. Was anybody with Mr. Owens during the elevator? The court. You want me to ask Mr. J? Mr. J. Yeah, perhaps. Just a general question. Has everyone been able to follow the instructions? Stay away from this case. The court. Sure, I could do that. Thank you. All right, this is the judge right now. Members of the jury, yesterday I told you that may happen to see a lawyer in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right. Juror in seat number 3 from my left, first row. Yes, ma'am. Juror number 3. I rode the elevator with the defendant's attorney. The court. Okay, thank you. Can you all approach forward just a moment? Mr. Owens. Judge, and I think somebody else did too. The court. Oh. Juror 4. I think it was pointing somewhere, I'm assuming. The court. And juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Juror number 4. I think it was one of the lawyers. The court. Do you recall who specifically, sir? Juror number 4. I believe it was him. The court. Mr. Owens. Juror number 4. Yeah. The court. Okay, thank you. Now we're at the bench. Do you want me to remove the panel and inquire of them one by one as to what they heard and any impact? Mr. J. I think at most it'd be, should be those two. And I'm deferring to the defendant. He's the one that brought this up. I have no concerns about what was said and overheard if it was hypothetically any of these people. Mr. Owens. I would just ask them if they would have any concerns that you would like to address privately. The court. Sure. Mr. Owens. And if not, we'll proceed. The court. Do you want me to ask them individually or in a group setting? Mr. Owens. I say group setting. The court. Okay. All right. Now we're in open court. All right. Thank you both for your honesty. I appreciate that. Something we talked about earlier this week, and that's one thing that we will require and ask of you is just be open and honest. And I appreciate both of y'all openness and honesty. During riding the elevator, was there anything that you saw or observed that impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row. Juror number 3 says, no, sir. Juror number 4, left to right, first row. Juror number 4 says, no, sir. The court. All right. Thank you. All right. With that, members of the jury, we're going to proceed with the opening statements of the morning. Oh, they haven't done opening statements yet. Okay. So this is the elevator right before opening statements. All right. I remember stuff like this happening. I just don't remember where in time it happened in regards to the trial. All right. So no issues here. We're at the bench right now. We have the court. Mr. J, how long do you anticipate your first witness being, sir? Do you guys remember who the first witness was in the Sarah Boone trial? Was it law enforcement or was it family member? No, I don't think the family members went until later on, right? The court says, Mr. J, how long do you anticipate your first witness being, sir? Oh, Mr. Cacciatore. I would say the court or Mr. Cacciatore. Good morning, Mr. Cacciatore. Yeah, good morning. Do you guys remember Mr. Cacciatore? He was the guy that was wearing... Every time we saw him, he looked like he was like a LA noir detective or something. I don't know. He was always like dressed kind of snazzy and like, was he wearing a hat or a trench coat or something like that? Hi, Northwest. How are you doing today? How's it going? During the elevator, cover the ears and scream, jur, 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 jur. There's a new family court filing. Brian objecting to all Sarah Boone's dumb filings. You haven't seen it yet. Does she have an attorney representing her, or is she just doing all the filings herself? Does anyone know? Poor Brian Boone. We'll never get rid of the Sarah Boone. Oh, and also we read in the sidebars, apparently Brian Boone doesn't want their son to have anything to do with Sarah Boone, which makes sense. Really? She's also going pro se. Okay, I mean, she just having fun while she's being incarcerated, you know? Passing the time. All right, Mr. Cacciatore, aka Mr. Trenchcoat. Yeah, good morning. Depending on the cross and how deep they want to get, I would say probably 20-ish minutes. The court. Okay, who is it? Mr. Cacciatore. It's Mr. Juan Torres. The court. The brother. The brother. Okay. Mr. Cacciatore. The other thing I would just bring to the court's attention, there's 2 other records custodians as well, one for the 911 call and for the Publix records. Again, Publix is a grocery store. Remember, there was like security footage of Sarah Boone and George going into the grocery store to buy like the Magnum bottles of the wine. I don't anticipate any of the cross on either of those witnesses. They're going to be like, I don't know, 5-minute witnesses. I was just hoping we could put them on before lunch. The court. Sure, that's fine. I think we could do that. Thank you. Yes, sir. Mr. J. I would ask that we enforce for local administrative order about addressing people by surnames and not just their first names. The court, please. Mr. Owens, tell me what I did. Mr. J. Well, you kept calling her Sarah. It's Miss Boone or Sarah Boone. The court, he's correct. There is a local decorum administrative order. Mr. Owens, all right, I know that George refers several times in the video, Sarah. The court, that's a different kitty because that's a different piece of evidence that's being admitted. But for the purpose of the parties or the lawyers referring to anyone, I ask that you use full names or surnames. It's appropriate in child cases to refer to the children as their first names, but not when we're dealing with adults. I actually have never heard that term before. That's a different kitty. Interesting. She can afford attorney court. Will give her family court. Really? I don't know what's going on with her in the family court stuff. Hi, Kuya. How are you doing today? How's it going today? Yeah, she got life sentence. Okay, let her serve her life sentence. Yeah, I just know the family court stuff is just a mess because it's just her versus Brian Boone, and then she was asking for alimony, child support, and maybe even Pop-Tarts. I don't fucking know. Okay, it's fucking Sarah Boone. I'm not surprised. Mr. Owens. Well, I meant to say Sarah Boone. The court. I understand, sir. I appreciate it. Thank you. Why did I label this orange? Man, when I read this about like 2 weeks ago. I don't remember what the color is, but I think green means like pertaining to the trial stuff maybe, or orange is like maybe not important. I don't know. We'll see. The court. Can the parties approach momentarily? At the bench. State, who might be your next witness? Mr. Cacciatore. Vincent Pataglia. Bless you. He's a neighbor. I would anticipate his testimony. Oh, wait. I think someone in the court was sneezing and the court was probably saying, bless you. Remember how the judge had a habit of doing that? Anytime anyone would sneeze, he would stop what he was doing. He'd be like, bless you. Bless you over there. Vincent Battaglio. Okay, Mr. Cacciatore says he is a neighbor. I would anticipate his testimony could potentially be as long as Mr. Torres, or it could be longer depending on cross-examination and the issues the defense may choose to explore with him. The court. Bless you. I'm on board with that because we got a later start. You know, if we got time to go into lunch for an hour a little bit, that's fine. Ballpark it for me. How long do you think? Like 20 to 30? Mr. Cacciatore, 20 to 30. The court, that's for direct and cross or just cross. Mr. Cacciatore, I think it's for direct and cross. The court, any reason to disagree, sir? Mr. Owens, I don't know. The court, I'm not asking you to hold yourself to it. Just, ballpark it. Mr. Owens, are you wanting to take a lunch at 12:30 or is that what you're shooting for? The court, yeah, that's fine. I could do that. I'm okay with that. Mr. Owens, we'll try to get there. The court, okay, excellent. All right, thank you. More bench stuff. Here's another bench. The court, I think now would be a good time stopping. It's 12:18. Mr. Cacciatore, yeah, it would be a good stopping time. The court, what do you say, gentlemen? 1:45 or 2? Mr. Owens, I would say 2, but if you could judge, yeah, we could ask for 2. But the other thing is, I've got a couple of experts. Dr. Harper is in Okaloosa County. Did I pronounce that right? Dr. Harper is in Okaloosa County. Dr. Brandon is in Miami. Just I know they probably know what they're all going to do. If they could just disclose something so I can get an idea, because both of them have to travel. One of them, Dr. Harper, gets cut off. The court is on trial call somewhere, as I recall. Mr. Owens in Bay County, Panama City. So, Mr. Cacciatore, what do you want to know? Mr. Owens, are you all we're not going to finish today? Mr. Cacciatore, no way we get done today. My anticipated, I think Monday late afternoon, we could potentially be looking at resting. If not, probably first thing Tuesday morning, The court, okay. Mr. Owens, well, that gives me an idea. Okay, Mr. Owens, do you plan on introducing any video, watching the 2-hour video today? Mr. Cacciatore, no, we won't do. Detective Kepsel will probably be Monday. Mr. Owens and the court both says okay. Mr. Owens, is a medical examiner testifying today? Mr. Cacciatore, I don't know if we would honestly get her to that point. We have her on standby for this afternoon, but I mean, it's going to depend. I can tell you that Brian Boone is probably the anticipated next witness, and I imagine he might be pretty lengthy for both sides. Oh, wait, so what Brian Boone did not testify, right? Is my memory messing up on me? He didn't testify, right? We didn't see Brian Boone? No Brian Boone at all? Oh my gosh, I don't think we saw Brian Boone. I wonder, why did they change their mind about Brian Boone? Hi, Christine. How are you doing today? It's good to see you. Hello. How's it going? He didn't testify, right? Hold on. Am I just having... Am I having an episode right now? Hi, Oahu. How are you doing today? Good morning, Corgi. Hello, Oahu. How's it going? He didn't, right? Or did he testify and it was like really short? He did? What? Am I confused? What was he testifying about? No way. Did he testify? Oh, you're right. He did testify. It was so short that I think I felt like nothing really came out of it. It was so short that Corgi forgot, okay? It was so short, I forgot he testified. What did he testify about again? What did he talk about? Oh, was it just, oh, you know what? Now I remember why it would be relevant. Basically, I think her calling him that morning and he's like, excuse me, why haven't you called 911 yet? And then he was telling her to call 911 and then he finally arrives and she was like panicking. And he was like, nope, I'm not going inside that house. Okay, I remember that. Okay, yes. Because she didn't call 911. She called Brian Boone hoping that she, be rescued by him and that he would, I don't know, take over and deal with the mess, I guess. I forgot about that. All right, thank you. All right, so Brian Boone, they imagine was going to be lengthy. And then we also have CSI to do, also have Abraham Moreno to do, all of those. I thought potentially we may only get there or maybe 2, maybe 1 or 2 witnesses after that. Mr. Owens, okay, that helps, yeah. The court, okay, I appreciate it. Just a reminder, both of you all have done it. You refer to George Torres as George. You refer to another witness by their first name. I'm not going to call you in front of everybody. Just please be mindful. Mr. Cacciatore, I apologize, Your Honor. The court, we could just continue for both sides to use those surnames. It's just an appropriate thing to do. I'm going to give the jury the same instruction I've given them, release them, and ask them to come back here 2 o'clock. I've got a question to ask of your client before we release her for lunch. Anything else we need to cover, gentlemen? Not from the state. No judge. At the bench again. The court says, yes, sir. Mr. Cacciatore, the lack of cross-examination was kind of thrown off our schedule for things. We have some Bluetooth speakers coming in to amplify the sound. The next item of business for the state was going to be published a 911 call. The court, well, it looks like your speakers just arrived. Mr. Cacciatore, oh, okay, great. The court, you spoke it into existence. If you want to deal with that issue, then if you still want to intend on calling CSI, Abraham Moreno, I believe who was it next? Mr. Cacciatore. There it is. It's not CSI. It's just a regular witness. Yeah. The court. Oh, sorry. Okay. Is it Abraham Moreno? It's Abraham. Oh, Moreno. It's Abraham Moreno. Okay. Thank you. Appreciate it. I might have just misheard you earlier. Thank you. Just let me know when you've got that set up. All right. The parties are approaching the court. If I understood the state, this was going to be the last witness here today. Is that correct? Mr. Cacciatore. Yes, the court. Okay, all right. I have jury certificates for members of the jury to give their employers about the extent of service. I'll be given the same instruction I gave them before the lunch hour. Anything else we need to discuss before I give the instructions to the jury state? Mr. Cacciatore, not from the state. Mr. Owens, it's a long weekend, you know. I guess a standard instruction would do it. Mr. Judge, it's going to be the same one that I read right before lunch. In addition, don't do any homework. Don't read the local news or newspapers. Okay. All right. Thank you all very much. What's the 3-day weekend in October? Is it Indigenous People Day? I don't remember there being a 3-day weekend. Maybe it is Indigenous People Day. I should know my holidays, but I don't. All right, we're at the bench again. The court says, yes, sir. Mr. Owens, Judge, I understand there was a delay. The security said that on Mondays, it's a really long line trying to get into the courthouse. The court, correct. Mr. Owens, so they have to go through security. Is there any other way? And I'm just suggesting, is there any other way they can get some kind of a secret pass to get through the side door like we do? Ooh, a secret pass? The judge says, I don't believe so. Mr. J, at the front entrance of the courthouse, the far right is the juror entrance, and I just think you should remind them that they can use that far right entrance and not get into the long line. The court, sure, I can do that. Mr. Owens, that's probably what happened. The court, yeah, that'd be my guess. Okay, anything else we need to talk about? No, sir. All right, very, very good. All right, what do we got here? Is this a long one? Not too long. Okay, I'm going to read some of the questionings of the back and forth testimony. Sorry, I'm going to read the testimony, the back and forth questions, just so we can get context of where we are at and why there is an objection. So this is testimony right now. And who is testifying? Who is testifying? Something about autopsies? Maybe this is this might be the medical examiner, maybe. All right, question. Who's asking the question? Maybe Mr. Owens? I think it's Mr. Owens. Oh, God, I think it's Mr. Owens. Okay. If it's not Mr. Owens, I'll let you guys know. Question. Okay, so really from that time, I guess it was 11:30 that evening, were the videos that you understood that the body was found to be around 12 o'clock later, 12 hours later the next day or so? Would you agree that the death occurred sometime within those two periods of time? Answer. Yeah, I would agree. Question. But we don't know exactly when that is? Answer. Yes. Question. So it would be a guess if we would try to speculate about that. Answer, yes. Question. Now, considering the 3,000 autopsy, how many cases have you ruled the cause of death as positional or postural asphyxia? Answer, handful of times, not very common. Question. So about 5 times or less? Answer, yes. Question. And we're going to talk about the environmental suffocation a little bit, but let's talk about positional asphyxia component. What was your ruling? Those 5 cases that you ruled that it was positional asphyxia. What was your ruling in terms of your diagnosis? Mr. Cacciatore, Your Honor, I'm going to object as to relevance. The court says approach. Now we're at the bench. The court, what's the relevance of these prior findings? Mr. Owens, I think, number 1, she's going to say that it's an accident. I think it's the literature that says the majority of these types of positional asphyxias are accident cases. The court, so how is that relevant? Mr. Owens, well, it just shows that this type of scenario with this type of asphyxia, positional asphyxia, that the majority of the cases are accidents. The court, okay, you repeated the same thing again. How is that relevant? Mr. Owens, that's all I've got. The court says, okay, I'm going to sustain the objection. Oh, Mr. Owens. Oh, how I missed you, Mr. Owens. He's a funny guy. Mr. Owens. The judge is like, okay, so how is that relevant? And just repeats the same thing again, but like in a circular manner. Not a holiday in Florida. It seems like it was a court holiday. The court had off. Oh, Mr. Owens, you're so funny. All right, next one. We got orange here at the bench right now. The court. Where are we in the state's case? Presentation perspective. Mr. Cacciatore, we have 2 witnesses on deck. I would imagine Miss McCaskill would be a shorter of the 2 witnesses. We also have Miss Udon, whose testimony I think is going to be a little bit longer. I'll leave it to Mr. J. He's handling those witnesses as to affixing a time frame. The court. Well, the reason I'm asking is it's 11 o'clock. It's 11 o'clock. I don't know if we want to take our mid-morning break at this time or... And then with that late start, we didn't start until approximately 9:45. I'm on board with working a little bit later this morning. Mr. J, we can ask them if they need a break. Otherwise, we're ready to do 2 more witnesses for the lunch break. The court. Perfect. Okay, very good. I don't know why I decided to read this. Why did I highlight this? I don't know. Just for fun, I guess. I don't think Mr. Owens is used to a judge required him to cite case law, lawful reasons for objections. I mean, isn't that how they do it in court, though? What is Mr. Owens doing? Oh, Mr. Owens, he's a funny guy. All right, we are at the bench right now. Court says, yes, sir, Mr. J. Judge, at the end of the session in the morning, we've already had some outbursts from the media. I don't know if you want to address that, but this afternoon, there's a lady in the back row on your left in the very far corner. She's already making outbursts. She's already going to cause a mistrial if she's to remain here. She's been going back and forth with the deputy. Mr. Owens, I thought she knew the deputy. The court, who might it be? Mr. Owens, the black female in the far right or far back. Mr. J, the female deputy can come up and tell you what's going on, I think. The court, my CO, Officer Jones. Okay, are we having an issue with somebody in the gallery? Oh, I remember this. There was someone in the gallery that was excused, and then she said something really weird as she was leaving. Like, bless you guys, and something else or something like that. I don't know. I don't know if they were like, I don't think they were in support or against Sarah Boone, but I think they just wanted to just be there because this was like a highly publicized case or something. I don't think we heard from them ever again. All right, so at this point, the court deputy comes up, says, well, what happened was when she first came in, I initially assumed that she had a court herself, which I told her just go to 19 Alpha. And then when I came back in, she was like, Officer Jones, you're fired. Damn, we got a Trump over here. And Deputy Bruce talked to her, so I assumed she wanted to watch Sarah Boone. They was inmates together, but she, the court. All right, so here's what I'm going to do. Thank you. The deputy court. The court. Mr. J, any further inquiry of Officer Jones? Mr. J, don't you all have anybody else? Mr. Owens, just the older man with, gets cut off. The court, I recall him being on the phone. Mr. Owens, he's older and he's hard of hearing. I've talked to him outside, so I think it was inadvertent that he needs to be. Gets cut off. The court, okay. Do you have any other inquiry of Officer Jones? Mr. J, no, sir. Counselor, Mr. Owens, nope. Okay, thank you. I will advise them to please silence all their cell phones so they're not going to have any outbursts. And if you cannot control yourself, I'm going to ask you to remove yourself. And if I hear an outburst, you will be removed. Okay? Mr. J, thank you. The court, okay, thank you very much. Anything else? Yes, sir. Mr. Owens, we have a lay witness. Her name is Pearl Walker. Oh, I remember Pearl Walker. Poor sweet old lady. She's an elderly woman. She lives here in Orlando area. She's cared for by her daughter, Marlene Walker. She said this, I understand my mother would be a good witness for Sarah. I just have to care for my mom. And we've had a significant loss in our family over the last year. My father, who she was married to over 60 years, passed away in May 2023. My oldest sister and her daughter passed away within days of each other. Oh, so sad. We have a funeral for them in the February 2024. She wakes up most morning crying due to the loss of her loved ones. She's 81. Damn, and they got her to testify? I mean, I guess so. Her heart could only take so much. I just took her on Saturday to get shots in her knees to help her with the pain of walking. Mentally and physically would be a lot to have her mother come into the courtroom. Is it possible she can participate via Zoom? Oh gosh, poor Miss Pearl Walker. Sorry, when I read these, I don't breathe properly, so my nose is like a little stuffy. How is everyone, by the way? How's your guys' weekend? Hi, Romania. How are you doing today? Hello, hello. I don't think Owens was used to a judge. Not a good old boy, Owens court. Give me a second. I forget to breathe when I'm reading sometimes. My nose gets really stuffy. Oh boy, okay. Breathe, Corky, breathe. Also, let me get a sip of water too. How are you guys doing today? How was your weekend? Anyone watching the retrial earlier? Your fake elbow cancer acting up, referring to the mushroom murder trial. Wait, what? I feel like you need to expand more. Tell me more about this mushroom murder trial and this elbow thing. I remember we were talking about the mushroom murder trial. Was this the one in Australia or something? I remember we brought it up, I think like a week or two ago. All right, so we're talking about Miss Pearl Walker. Poor Miss Pearl. Mr. J, you're looking at me, so I'm going to give a response, Judge. I believe testimony by video is something that should be addressed with a motion, so the state can respond and the court can issue a ruling. Quite frankly, two of the, I don't know, as far as I know from the communications of the defense team, they narrowed down to 3 civilians out of the plethora that we've had that they're going to call. This is one of those 3. One of them, I can kind of understand what the testimony is based on the phone extraction. That's Deborah Johnson. The other 2, we have actually no idea what they're going to say. And I understand that they have an investigator who has been in trial with us every day, rather than perhaps getting us affidavits to help to give us any help. So we're going to require, unless the court orders otherwise, an in-person deposition. The court. Are these one of the persons that were identified in your objections? Mr. J. Yes. Who was it? Because I only have initials, unfortunately. Mr. Owens. Pearl Walker. PW. Okay, got it. Based on the court's ruling early in the case, if you were going to call any of these people, they need to be subject for depositions first. Mr. Owens. I think we got some scheduled for as soon as we get out of here, 5:30. We've got witnesses coming to be deposed, but I think Billy Lane had actually interviewed her and he's got a summary of her testimony. I'll get it to the state so they know. But I do have Marlene Walker and Pearl Walker some phone numbers so they can call. I just talked to them during the break. That's the reasons I'm giving this information. The court. Sure. Mr. J. I'm not going to talk to witnesses on the phone and have unrecorded statements that I can't testify to. I need their depositions. The court. That was the court's ruling. Mr. Owens. I understand. Mr. J. But if I had an insight, then I could perhaps discuss the reasonableness of video testimony, but I don't have any insight of what these people are going to say. Mr. Owens. Can I try to get them here at 5:30? Mr. J. Well, we've got to decide how late we're going to stay in the courtroom. The court. Yeah, okay. So bring up the other issues. Are there any other issues? Mr. Owens. Yes. The assistant to Mr. Brandon, he lives down in West Palm. Right. Mr. Owens. Good afternoon. This is 1:36 p.m. reaching out to see when you anticipate meeting Dr. Brandon. We kept his schedule open for Wednesday, October 23rd, but I need to know if he'll be needed that day as soon as possible. Please. So that's something we need from the state to know whether or not he can testify on Wednesday. And then on the other thing is that I got something from Dr. Harper. She's in the Bay County homicide or sentencing on a death row case. The prosecution is still on today. They asked me to be in the Bay County tomorrow, which would be Wednesday, and will send me on an update at 5 o'clock tonight as to what time I need to go tomorrow. If that's late, last witness, I would expect cross to be Wednesday a.m. I will text you as soon as I hear anything at 5 o'clock. So I know something from her at 5 o'clock today, Central, 5 o'clock Central Time. It's kind of hard reading his words sometimes. I feel like it's kind of like all over the place. Okay, so it was Australia, right? Australian lady poisoned 4 in-laws claimed to have bowel cancer. 4 in-laws. What? What was the motive? My goodness. Okay, so Central Time, 5 o'clock. The court. Okay, tomorrow's Tuesday. Mr. Owens, what's today? Monday. The court. Today is Monday. So she's set up to testify on Wednesday in Bay County. Mr. Owens. That's what she says here. The court. Okay. Mr. Owens. She says they asked me to be in the Bay County tomorrow and will send me an update at 5 o'clock tonight as to what time. Hi, Carolyn. How are you doing today? Hello. Mr. Owens is a funny guy. I feel like Mr. Owens is a lot of talking and not a lot of listening sometimes. So tomorrow is going to be Tuesday. Huh? Then what's today? It's okay. It happens. Sometimes your mind is just wandering, I guess. The court. Excuse me. I would very much appreciate it if you all could just keep your comments down. Thank you. Mr. Owens, here's the court. I have no reason to doubt that what you provided to me, okay? I don't know the order of proof you intend on putting on case. I don't want to pre-state anything, but it seems like, Mr. Owens, Sarah Boone is going to have to go first. The court, correct, Mr. Owens. And so that's going to probably be if you all finish. Oh, that's Mr. Owens, I guess. So that's probably going to be if you all finish, gets cut off. The court. I would assume that it's going to be the majority of Tuesday. Listen, can we get the jury in here on how late they can go? Mr. Owens, okay. The court, assuming we can go to 5:30, 6 o'clock tonight. Damn, I forgot. I think it was the Sarah Boone trial that we're going on so late. Man, unlike the Karen Reed trial, we get it out early. All right, the court. Assuming we get to 5:30, 6 o'clock tonight, that still leaves your cross-examination of Detective Capsule tomorrow morning, which you said would be around, 30 to 45 minutes. Assuming worst case scenario, you start promptly at 9 o'clock. You're at 9:45, approximately 15 minutes for rebuttal, for redirect. Just being worst case scenario, 10 o'clock, state rest. We have JOA and colloquy your client on a couple of things we've got to go over, which means we kick off your case at 10:30. I don't know how long your inquiry will be. I don't know if it's 2 hours long or longer than that. Assuming 2 hours, that takes us to 12:30. We take an hour and a half break and come back at 2 o'clock. 2 hours for cross-examination. Basically, Tuesday is Ms. Boone's testimony, which then leads us to Wednesday. Now, if Dr. Harper's testifying in Bay County on Wednesday, I don't know how your order of proof on who you want to present when, where, how. Mr. Owens. We'll probably try to have Brandon's available Wednesday, so we probably would want Brandon. Mr. Beck. Mr. Beck. Oh, Mr. Beck. Okay. Just got off the phone with Dr. Brandon's office. He's scheduled to come in Wednesday, although I'll have to let him know because he's scheduled a doctor's appointment anyway. But I think he's available Wednesday morning, first thing, early in the morning. He's 3 hours away, so probably, maybe 10 o'clock is a good estimation for his arrival and testimony. Julie Harper told us originally that she would be over testifying on Tuesday. We got an email from her over the weekend saying her testimony was going to be Tuesday or Wednesday morning. That's okay. I think that the court... I think the text updates that Mr. Owen has provided looks like she's going to be testifying Wednesday. Mr. Beck. Oh, okay. The court in Bay County. I think we might have to be malleable with this. I don't want to press too hard this afternoon. I want to try to get as much as we can done. I'd like to have a clean break. I don't want to be in the middle of examination and have to pick up where we left off. Mr. Owens, judge, of course. We'd love to be finished by Thursday or Friday and have the jury with the case. The court. Okay. Mr. Owens, that'll be your goal. The court. Fabulous. All right. We may have to just revisit scheduling stuff either at the close of business today or tomorrow to figure out where we are. So in regards to Ms. Walker, PW, look, I already ordered that she's going to give a deposition before she testifies. Now, if there is investigative summaries or something that Mr. Lane can give to the state, they can make a decision on what they want to do. They can waive the right for a depo. That's a decision. With regard to the virtual appearance, I need you to file a motion. Explain to me that you told me and anything else, and if the state has provided a summary that may assist in a response in that matter. And then the last thing to address is just discussing with our members of the gallery as to the silencing of cell phones and controlling themselves in that regard. Mr. Owens. And then you can ask what the jury, what is it? And then you can ask the jury, okay. Mr. Owens. And then you can ask the jury about how late they want to go today. The court, I am, Mr. Owens. And based on that, we'll try to coordinate depositions. The court, correct. So the only issue is that we may have to send them right back because of the one juror I can't recall where she's situated. She has a minor child care issue where she can't go past 6 o'clock. So we got to vet that out. Now, if she cannot get coverage or if it's me and me only, I'll bring you back here. We'll figure out where we want to break because I don't want to derail anyone's presentation in any way. Okay? All right. Anything else? No, sir. No, sir. All right. No issues here. Whew. Good podcast. Mushroom Case Daily. Are they covering the trial right now? How long do they expect the trial to be? All right. We are at the court right now. The court says, yes, sir, Mr. J. According to my victim advocate, the defendant keeps on turning around and smiling at a woman in the last row. That's going to be a potential problem. I'm really, really concerned that she's going to see something to derail the trial. Mr. Owens, I'll tell my client not to turn around and talk to people in the audience. The court, I just saw her. Mr. Owens, or make comments to people. Unless you want to do it, Judge, I'll let you do it. The court, I just saw her turn around and make eye contact with someone in the gallery, and it was not your staff. Mr. Owens, I'll tell her, or you want to tell her. The court, I prefer you to tell her, and I would inquire of her specifically as to if she knows anybody and how she knows those persons. And I need you to come back and report to me what it is. So I remember when we were watching the trial, people were speculating that Sarah Boone had a girlfriend that was in the courtroom, maybe. And they were speculating that this girlfriend had also served time with her at the Orange County jailhouse. But I don't know if any of those rumors were ever substantiated or anything, but I remember hearing that floating around. 5 weeks trial? Mr. Henderson. Is it the same person before? The court. The same woman before? I don't understand. Mr. Henderson, who made the comments to? Mr. J. Yeah. Mr. Owens. Sarah Boone says she doesn't know anybody in the gallery, but because of all that we just said, she was just looking to see who it was. The court. All right, Mr. J. Mr. J. I know it's a public trial, but that woman is going to cause a mistrial. Mr. Cacciatore. At this point, I think she's forfeited her right to be here. The court. What exactly have you seen her do specifically? Mr. J. Well, before you came in here, she yelled something out. What did she say to? Mr. Cacciatore. I believe it was a loud conversation going back and forth, and just given the sensitive nature of this, we picked 8 alternates for a reason. We won't be able to unring any of these bells. She doesn't have any business here other than the fact that she's a member of the public and she's forfeited her right to continue to stay in here. Mr. Owens, it is being live streamed. I know that. Mr. Owens, so people can watch it. Mr. Cacciatore, I think defense is in agreement that she should leave. Mr. Henderson, I'm in 100% agreement because of this. If something happens now, we've been into this thing. The court, I know. Okay. Mr. Henderson, all the safeguards, Judge. The court, politely, any thoughts from either the state or defense as to how to ask the woman in the back left to excuse herself? Oh my God, this judge is so nice and polite, man. Mr. Owens, just the fact that when security officers walked in, she said something in a loud voice. Oh, here comes the deputy, whatever her last name is. Here comes, even though it was off the record and you weren't on the bench, it's still inappropriate in a courtroom. Some people don't know how to act in a courtroom. It's just inappropriate. Then she called out, hey, does anybody got a pair of eyeglasses I can wear? I turned around and said, what number do you need? Is this Mr. Owens? Somebody in the front gave her a pair and she tried them on and gave them back, but just to relax. She's to relax the seriousness of these proceedings. Mr. J. I think perhaps even before Mr. Owens got in here, when she first came in, the female deputy, the Orange County employee, told her to go up to 19A. I know who you are from the past. I don't know if she's another defendant or because I couldn't hear what she said when she was up here. I was behind her. The court. She said that she was supposed to be that woman was here for court and directed her to 19 Alpha, and that was when the squabbling had begun. So, Mr. Henderson, what about the request of counsel? You can even put my name in it. I don't care. Damn, Mr. Henderson. The court, all right. Mr. J. She had another outburst when she said she was a mayor of Orlando or in charge of Orlando, the entire city or something like that. The court, I got it. All right. So here's what we're going to do. I'm going to say at the request of both the state and the defense, ma'am, in the back left last row, I need you to excuse yourself. You're able to watch it live. The court's link is streaming. You can go to 12th floor and call my JA and she'll give you instructions on how to watch it from a streaming device. Is that acceptable? Oh my God, the judge is so nice. He's like, I don't want to kick this woman out even though she's being disruptive. How can we say it in such a nice way? Mr. J. Thank you. The court. Okay. Thank you very much. So at this point, this is where the judge tells the woman to leave. All right, ma'am in the back left last row. Ma'am in the back left last row. Good afternoon. After conversing with the state and the defense, they have agreed and asked me to excuse you from this room. I understand there may have been an outburst by you with courtroom personnel before the judge arrived on the bench this afternoon. If you would like to watch the trial, it is being streamed live. You can head to the 12th floor, get off the elevator, head to the south side of the building, and you will see signs where it says Judge Michael Kranick, and it will tell you which direction to go. You can pick up the phone, call my judicial assistant, Anita Barrios, and she can give you instructions on how to watch this trial virtually. Okay? Unidentified speaker. Okay. Thank you so much. Thank you, ma'am. God bless you guys. I'm still the boss of this city. We still got work together and try to figure it out together. All right. Thank you, ma'am. So they got her arrested. Have a good one. All right. Thank you. Bye. Yeah, I remember they left and that was just about it. You know, no crazy outbursts, you know, nothing too crazy, nothing like violent or anything like that. They just said something weird and then they just got the fuck out. So all right, bench time. Where are we at in the trial, do we think? Have no idea. No clue. I wish they would set the days on the bottom of the transcript or something, just so we have like a little bit of idea of like who's testifying, what day it is, where are we at. But we're at the bench right now. The court. My takeaway, Mr. Owens, is that you do not have the opportunity to review it yet, so I was tabling it for a moment. Mr. Beck. Well, it should be done in camera is what I'm saying, not in public. Mr. Owens. This is not in camera right here. Mr. Beck. It wasn't. The court. We're at sidebar. I don't know if that's in camera, nonetheless. If you're in the position to address it now, I'm fine with that. My takeaway is you are not. Mr. Beck, I briefly looked at it. They haven't even looked at it. I was just trying to understand where he was coming from. Is he saying that we're going to request costs for post-conviction travel costs? Mr. J, do you want me to say what I want to say? Yes, Mr. J, please. Mr. Owens, yes. Mr. J, okay. Here's my concern. The defense team is comprised of 4 attorneys, a trial jury consultant, and I don't know what their backup support staff is. But beyond that, the only thing that I notice is getting paid for the JAC is Billy Lane. And the experts, Mr. J, and the experts. But beyond that, this is a tremendous expense to come down here, shut down. I believe he described it as shutting down his practice for a month and coming down here and speaking to one of the other members of the team. It seems like other members of the team are getting paid by Mr. Owens. At the end of the day, I'm wondering, where is this money coming from? I think we're all wondering that as well, and they addressed that. Is this just a charitable gift? Which is fine if Mr. Owens wants to provide a charitable service and get his pro bono hours for doing this case for Ms. Boone. That's fine. But if that's some sort of deal with Ms. Boone about story rights, anything like that, then there becomes a potential conflict of interest. I don't want her to make allegations in a 3.850. If she gets convicted, we all know there will be appeal. If there will be a 3.850 if the appeal fails, and I don't want anything to be about a conflict of interest saying, well, I would have pled, but my attorney didn't do what he should have done in getting me pled, for example, because of the contractual agreement we made for how he's going to get paid for all of this. So the state doesn't even need to be a part of it. We just want to prefer that there's an in-camera hearing so that this can all be put on the records. See if there's an actual conflict or if there's an actual conflict to whether Ms. Boone, under the case law, knowingly, intentionally waives any conflict for purposes of 3.850. After that in-camera proceeding, it can be sealed and unsealed if there's like 3.850 someday. Mr. Owens, I think we need to address it later. There is no deal. There is no conflict. The court, I'm going to give them the opportunity to review it. Mr. Owens, we're going to address it on the record, the court, and discuss it themselves. I'm not going to address it right now because by your own admissions, Mr. Owens, 2 or 3 of the members of your team have not reviewed it. And Mr. J, I do have a slight correction. My understanding is that Mr. Henderson's daughter was recently barred, so there are 4 attorneys working over there. Mr. J, that's what I said. The court, I thought you said 3. I apologize. Mr. Owens, she hasn't filed a notice of appearance. The court, I understand. As an attorney on record, the court, I get it. Let's table it. I'll look at it during lunch hour and we'll readdress it if necessary this afternoon. Congratulations to Mr. Henderson's daughter. Anything else we need to address, Mr. J? No, sir. Anything else we need to address from the housekeeping perspective, from your all side of the ledger? No, sir. All right. I mean, they did address the book deal thing. I don't know how that book deal thing came into rumor. I wonder if it was something that was started on the internet and then Mr. J picked up on it, or who started this rumor? But it was addressed at court on camera, and Mr. Owens said he was not getting story rights or anything like that. But I do remember Mr. Owens saying that he had to shut down his law firm for like a month in order to do this. So if I was Mr. J, I'd be a little bit sus too. Like, where is his money coming from? From the jail messages, you think? I don't know if I heard anything about that. What did you hear about the jail messages? All right. Again, we are in testimony right now before we go into sidebar. Is this the detectives, I think? I think this is Chelsea Kepsel, maybe. Jail messages, Sarah talking to, video producers? Interesting. All right, question. At that point in time, have you told Ms. Boone she was under arrested? Oh, I think this is maybe Mr. Owens, maybe? Is this Mr. Owens? Mr. Henderson or Mr. Cacciatore? Mr. Henderson. I think it was maybe Mr. Henderson. Okay. At this point in time, have you told Ms. Boone that she was being under arrest? Answer. I told her at the end of her interview. Question. Before the interview? Answer. No, I did not tell her before the interview. Question. Ma'am, why didn't you tell her before the interview? Because he wanted to get some answers out of her. Mr. Cacciatore, Your Honor, I'm going to object as to ask and answer. The court overruled the witness. So I have to read her Miranda warnings, and that's what I did. I don't have to tell her she's under arrest at that time. Mr. Henderson, was there a reason? Could you have told her that she was under arrest before reading her Miranda warnings? Mr. Cacciatore, Your Honor, I'm going to object as it calls for speculation. Sustained. Mr. Henderson, ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings? Mr. Cacciatore, Your Honor, I'm going to object to relevance. Approach at the bench. The court. How is the sufficiency of Miranda a fact of consequences for the jury to consider? Mr. Henderson, it goes to the voluntariness of her statement, Judge. The court. But isn't it that an issue for the law for the court that was previously decided in the motion to suppress? Mr. Henderson, the issue of the law for the court if the statement comes in, but to the weight they give the circumstances around the statement and everything else that takes place around the statement is totally relevant. Anything further, says the court. Mr. Cacciatore, Your Honor, the jury instructions don't contemplate the jurors relitigating the motion to suppress. They are given specific instructions about that deals with them weighing the voluntariness of the defendant's statements. But that analysis is predicated upon the objective four corners of the evidence of the defendant's statement, the conduct of the officers on the video towards her, the fact that the defendant would be aware at the time, but in that analysis, the officer's subjective intent is really irrelevant. What's relevant is their objective conduct towards the defendant and the facts that she would have been aware of. Yeah, Sarah Boone got really pissed because she came in hoping to get her phone back and she was yapping away. And then at the end, she was caught off guard, I guess, that she was being arrested. And she felt like she was being tricked in order to be there. And they manipulated her. Dude, the look on her face when they're like, yeah, we're arresting you. And she's like, what? Because remember, she had like a list of questions that she wanted to ask. She's like, okay, well, I have a list of questions. You know, do I get the ring back? When do I get the ring back? Okay, and when do I do this? When do I get this? Okay, how do I do this? How do I do that? And then it was like all pointless anyways because they were just going to arrest her. All right, the court. Anything further? Mr. Henderson. Yes, Judge. I believe there is a difference with people when they knew that they are under arrest, because then when the Miranda warnings are read to them, they have a different idea before they are read it. And I believe law enforcement knows that, as I believe this was a strategic decision for her because she was more likely going to talk to us about knowing that she is not under arrest. The court. I'm going to sustain the objection because I don't think subjective analysis from law enforcement and the question seems to be geared towards the officer's subjective analysis. It's whether or not the jury instruction 3.9b as to whether there was a force or whether anyone made promise or whether it was freely or involuntary made. It seems to be from the perspective of the defendant, not from the perspective of the law enforcement. So I'm going to sustain the objection. Next one. All right, the court. Can the parties approach for a moment? I understand what it is that you want to do. I get it that you have not participated in the viewing. My most pressing concern is our time with our jury. We have wasted substantially amounts of it. Oh, this is with Mr. Owens. The viewing of what? Something about Dr. Brandon. Dr. Brandon. What are we talking about here? Oh, okay. I remember this was a long one, but I think this was done in open court, right? Yeah. Dr. Brandon was an expert for the defense. The overt act. Okay, remember overt act. All right, let me just read the rest of it and we'll circle back possibly. Okay, let's do this. Mr. Owens, Judge, I don't know if I would have to say wasted. I mean, we've been working. From the judge, from their perspective. That's right. Okay, so I think they were basically, they had the jury excused, and during that time they were doing something, and then Mr. Owens was like, well, actually, you know, I need to do something. I need to talk to her or something like that, and it's gonna take me 15 minutes. And then the judge is like, well, we've just been here and the jury's been waiting. Why didn't you do it during that time? And we're wasting time here. And the judge is like, we're not wasting, or so Mr. Owens is like, we're not wasting time. We've been working this entire time. All right, so the court. Okay, they're sitting in that room waiting to be brought in, and now I'm going to bring them in and excuse them again for early lunch. I understand that's a lot of work and everyone is doing an excellent job so far, but we need to be more efficient with the time that we have. If there are exhibits on either state or the defense that intends on using, let's pre-mark them during the break, all of them. So we maybe not get the rebuttal evidence because the defense had not arrested yet, but at least for any evidence you intend on eliciting over the next couple of days, let's go ahead, pre-mark it so there's no concern, no question, no last minute markings. If it comes up, we will address it. Mr. Owens, can we do it during lunch? The court, we're going to recess in the next couple of minutes. Mr. Owens, can you give us and the clerk some time? The court, I will have Madam Clerk stay behind so that you guys can do that. Oh, poor Madam Clerk, no lunch for her. The state should probably be here for it to confirm. We'll bring the jury in and I'll ask them to be back here at 1 o'clock. And at 1 o'clock, we need to be ready to go. Mr. Owens, I understand. And Judge, if I started, I wouldn't be finished before lunch. I understand that. Mr. Owens, it'll be broken up anyways. The court, I agree with you. I'm trying to avoid it. Mr. J, Judge, I've had an opportunity to take depositions of the last two witnesses last night. I'm just curious as to when this third witness is flying in from Jersey and is going to be deposed so we can start making arrangements with that court reporter. The court, who is that? Mr. J, I believe it's Deborah Johnston. Who's Deborah Johnston again? Mr. Owens, I think there are people that 4.5 years ago were tenants of the apartment when this occurred, but they have been dispersed. The court, so you took PW and who else last night? Mr. J, I would have to see her full name. Last name is G. All right. MG? MG. All right. Got it. All right. And then as for, okay, when do we expect Miss Johnson to be arriving from New Jersey? Mr. Henderson. We tried to contact her last night, Your Honor, and she was asleep. The court. Okay. Mr. Henderson. We're trying to work with Mr. Owens, United Airlines, flying in, I believe, Wednesday at 9:05 a.m. Mr. J. Guess we're doing it Wednesday night. Mr. Owens, it'll be Wednesday morning. Mr. J, right. The court, correct. I see arrival time at 9:05 a.m., so it's either the lunch hour or Wednesday evening, because I don't know with when the defense intends on offering that testimony. But in my pretrial ruling remains the same, that before the persons are allowed to testify, the state has the opportunity, and similar with you, if it's a rebuttal witness, you'll have that opportunity as well. Okay? Did you have an opportunity to address the USB to the CD conversion? Because it was on my list from yesterday. Oh, I don't think this is important. USB to CD conversion. That sounds fun. What do we got here? Question. Is this when? Oh, this is when Sarah Boone is testifying on the stand. Okay, so we're at this point. Sarah Boone is testifying on the stand and direct examination by Mr. Owens. Mr. Owens. Oh, now we know why it was like the questioning happened the way it did. Because remember how when Sarah Boone was testifying and they were like, Mr. Owen seems like he's really kind of like guiding her and leading her a lot. It's as if he's testifying for her. All right, question. Okay, now I want to get directly to the date of this event so that the jury can hear your testimony. All right, so tell us. I believe the date is February 23rd of 2020. Explain to the jury that whole day from the time you got up, the whole thing. Mr. J, objection, calls for narrative. The court, approach. The court, response. Mr. J, I'm just making sure. Is there a reason for the narrative? Mr. Owens, I mean, I could break it up. I could break it up. The court, then go ahead and break it up if there's not any. Mr. Owens, if there's anything wrong with me saying, can you tell me what happened that day? Let her tell it. I mean, he was wanting a narrative to begin with. I'm giving her the opportunity. Mr. J, here's the issue. I was just making sure that we weren't getting to the stage of ethical issue of having to give the narrative. But if we're not, then I'm just hopeful that, like a prosecutor would have to do, that he would come up with a few creative ways of saying what happened next so I can, so it's not a narrative and we can break it up and object. Mr. Owens, you see me guide her. She tried to go off a couple of times and I tried to get her back. The court, I'm not going to allow a full-blown narrative. If you want to start morning, afternoon, break it up into chunks of time, I'll allow that. All right, I appreciate it. All right, still in the Sarah Boone testimony. Who is this? I think this is still Mr. Owens. All those things said by the men were said by George in the last 2-minute video. Answer, correct. Question, all the words said by the female were said by you in that 2-minute video. Answer, correct. Question, were you intending on showing him the video the next day? Answer, yes. Question, at the time or the next day, is it fair to say you don't remember videotaping? Answer, I do not. Question, okay. So for what you can tell me from watching it, did that refresh your memory about that event? Answer, it did. Question, what did you say all that? Why did you say all that? Objection, may we approach at the bench? Yes, sir. Judge, it's my position that they have not established an overt act. I understand it's one of the things to allow her to testify about why she did these things. Oh, that's right. We were arguing about the overt act. What did George do that prompted Sarah to do what she did, right? The overt act. Oh, we were juggling our juggling our memory, jiggling our memories, juggling. I understand it's one of those things to allow her to testify about why she did any of the. I understand it's one of the things to allow her to testify about why she did these things, but I don't want that to be considered a waiver of any objection about reputation, past violence, and battered spouse syndrome coming in a different way. The court response, Mr. Owens. Well, Judge, where, this event is broken down to 2 minutes. Why did she say what she did when was recorded? Why did she say what she did and was recorded? And I think she's going to say, I was angry at him. He was in a confined space. He was not free to get out. And it was my chance to tell him how I felt. And then, of course, 11 minutes later is the 22-minute video. The court, 22 seconds, 22-second video? Mr. Owens. Right. 11 minutes later, the 22-second video, there's an 11-minute period where she's got to testify about what happened during that time. So, I didn't know she was going to say she was incarcerated. The court, I know, I don't think anybody anticipated that. Mr. Owens, so some things come out of clients' mouths that we don't expect. Mr. Court, I understand. Mr. Owens, if you want to proffer it outside the presence of the jury, but I think she's going to say, I'm going to say, why did you say those things on that 2-minute video? And I think she's going to say, because I was angry. I wanted to tell him how I felt. But that's what I believe the answer is going to be. Not because, well, you choked me and you know what you done. The court, is it possible the question to avoid any prior answers coming out at this point in this time? Is it possible to rephrase the question specifically as to the feelings that she had been having at that point in time and only those things? Mr. Owens, okay. The court, so that we avoid that issue? Okay. All right. So they're basically trying to avoid any prior instances coming out between Sarah Boone and George. That's why the judge is asking Mr. Owens to just isolate about her feelings about that time. Not why she do it, and maybe she did it because, George did X, Y, and Z to me before. All right. Question by Mr. Owens. Again, this is still, I think, Sarah Boone. Yep, Sarah Boone's on here. How did George's drinking adversely affect you? It would debilitate my ability to help him the way that I was always trying to help him. Because it would be one good day, a day of survival, and then it would be another day when I'm having to peel him off being called 911. Question. Why would he get that way? Tell us his pattern as it relates to drinking. And then, Mr. J, judge, object, approach. Mr. J, judge, I don't think pattern is appropriate. If there are specific instances of violence that the court, are we getting into reputation? What are we getting into? Mr. Owens, I think it's consistent with what I've argued before, that when there are times when, he would drink and then she'd just come over, you just get to know a person, you're living with them, you're an intimate partner. Over the time, you learn that when he gets to a certain level of intoxication, that he gets sad or moody, and then eventually he gets angry, belligerent. And then there's times where he gets violent with Sarah. So it's just a cycle. That's why she said I was trying to keep him occupied the next day, because she knew that if he's got the alcohol there to drink, he's going to consume it. And then it might be at a point where they get into a violent episode, and that was just that they were going 3.5 years, so you can imagine there's a lot of history of that going on, and I'll refer to it as the court. Any other further argument? Mr. J, I just think we should get into the specific dates, get into those, because one person is not a broad enough community for reputation evidence under the rules. Mr. Owens, and she's not going to say remember every date, oh, she's not going to remember every date. It'll be hard to remember. Hi Lauren, how are you doing today? Hello. How's it going? Mr. Owens, and she's not going to remember every date, Mr. J, let's go through what she remembers. Mr. Owens, excuse me. Mr. J, let's go through what she remembers. Mr. Owens, part of the syndrome, the court, Mr. Owens, part of the syndrome of battered spouse is depression and then not having a good memory about all the events due to the repression to, or whatever the doctor testified to. Is not having good memory about the event due to the repression or whatever the doctor's going to testify to. But there's going to be evidence that the court, my concern is utilization of the word pattern. It sounds like we're getting to habit evidence here, which is, I don't think something you can get into. Now, if you want to rephrase it and say, this is what would happen and this is the circumstances that seem to continue, it might be a different story. But the word pattern is something I've got a problem with. Mr. Owens, tell me what you all are thinking about, because I don't want to violate the court's ruling. The court, my understanding based on the case law is that there can be reputation evidence for prior incidences, and we're kind of dancing between the two of those. And this is what generally what would have, this is generally what would happen. He would drink, become emotional, become sad, and then aggressive. The state's concern, I think, is that the use of pattern, which I think we're going to habit and routine practice, which I don't think is permitted for the circumstances you're trying to offer it for. Mr. Owens, okay. The court, so you can rephrase it, and then we need to start getting to specific instances. Mr. Owens, okay, thank you. Skip this bench. Next bench. All right, who's testifying at this moment? They're at the bench right now. The court says, Just a request from the jurors as relayed to me by the deputy. If the pictures are going to be shown, oh, I remember this. If the pictures are going to be shown, if they could be tilted so they're not landscape and vertical because they're tilting their head in a weird way to see them. Mr. Owens, my bad. The court, no worries, just for the future. Just wanted to let you all know. Okay, thank you. So basically, Mr. Owens, when you're giving pictures to the jury to view, have it all in one orientation. That way they're not breaking their necks to see the damn evidence. Oh, Mr. Owens says, okay, it's okay. It happens. All right, Sarah's still testifying. Owen says, Sarah, tell the jury, Mr. J, Judge, can we approach? Yes, at the bench. Mr. J, local administrative order, surnames. Mr. J, you're such a teacher's pet. The court, he's right, so please. Again, they don't want anyone saying like Sarah or like George, either say Ms. Boone or say Sarah Boone, not just like their first name. You may proceed. Question. Ms. Boone, tell the jury why you lied to the police. I lied to the police, basically everyone, because I was extremely fearful of being arrested. I made the first attempt of calling 911 by telling them what happened. I thought they were going to help me, but instead I was arrested for calling 911. Question. So did you make the decision to lie? Question. Answer. I did. Question. Did you say with that lie? Answer. I did. Question. Are you telling the truth today? Answer. I am. It's like, yeah, I've been lying the entire time, but guys, trust me. I was lying before, but I'm telling the truth now, okay? Just like the Murdoch thing. I was lying before, I didn't trust law enforcement, but I'm telling the truth now. Sure. Her voice is more snarky. She wasn't snarky though when she was during examination. She was like meek and like, I don't know, like a little girl's voice like this. Like I can't even do it, okay? It was like so like, she was trying to play innocent, okay? It was a little too much. Snarkiness is when do we, I think did she get snarky in cross-examination? I don't think she did, right? Sarah Boone's the type of person who doesn't really get snarky until it's in writing. Because I swear to God, when we see her writing versus how she would present herself in the hearings, in the case, that snark level was like not really there. It was like she really cares about her image, and the image is that, oh, look at me, I'm just a little victim, oh gosh. All right, let's read this one. Redirect examination by Mr. Owens. Yeah, cross-examination. I don't remember if she was snarky or not. Okay, Mr. Owens, redirect. Ms. Boone, he just asked you a question that you poked him and you didn't poke and you poke, and every time you poked him hard with the bat, he was inside the briefcase? Answer. The suitcase, yes. Question. The suitcase. But you remember when he put his hands out, did you not hit him in the hand outside the suitcase? Answer. Yes. Question. Okay. So that was the only time the bat touched Mr. Torres' body outside the suitcase? Answer. Yes. Question. Was when you hit him on the hand, but all the other injuries, were you poking him pretty hard? Oh gosh, I remember this. It was like, yes, George looked like he was beaten, but it wasn't because she was hitting him or swinging in the bat, like she was trying to hit a home run. She was just poking him. What do you mean? I don't know why the injuries look that bad. Answer. Correct. Question. I mean, you bruised your hand, correct? Doing it? Answer. Correct. Mr. Owens, thank you. That's all I have. Really? That's all he had for redirect? Or is this like a redirect, like redirect times 3? That's all he has? I don't know if I remember this. All right, ma'am, you can return to the counsel's table. Judge, can we approach for a moment? Just for a moment. Let me get her situated at the table and then we can approach. Defendant steps down. All right, come on up, you all. At the bench. Mr. Owens, Mr. Henderson has got some bad news. Okay, what's the bad news? Mr. Owens, I said you've got some bad news. Mr. Henderson, the bad news? The court. Mr. Henderson, can you get a little bit closer? Mr. Henderson, oh yes. The court, yes sir. Mr. Henderson, Judge, I let the officers go. I told them, like I informed the court, that I was going to do based on the time schedule that we're in. I know we're over. The court, that's fine. Mr. Henderson, I didn't think that was the court. It's 5:40. Mr. Owens, we don't have any witnesses. Oh, we don't have any witnesses. The court, I understand. We'll pick up tomorrow morning. That's fine. No big deal. That's okay. I anticipate the cross to be a little bit longer. I think we may all have been, but it's no big deal. Gentlemen, anything else we need to discuss before we go into the recess for the evening? Mr. J, no sir. The court, okay, let's be ready to rock and roll at 9 a.m. Yes, sir. Mr. Beck, I was just curious whether or not we're going to address the motion to stay filed this morning in camera evening, or are we going to do that later? The court. I'm not going to address it yet. We can just address it later when we get closer to jury instructions. Mr. Beck. That's why I was curious. Mr. Owens, we've got an issue. By 5 o'clock today, you ordered us to have redacted down the medical records. We need more time, Judge. Can we have a little more time? The court. Here's my concern. Mr. Owens. Mr. Beck is working on it. The court. Here's my concern. Is Dr. Harper is supposed to testify on Thursday, and the state needs to, understand what it is that you all are looking for. Mr. J. That's not the issue. I'm familiar with the records she relied on, and they can, of course, rely on stuff that's inadmissible. The court. Yeah, of course. Mr. J. Well, my concern is what particular pages do they seek to introduce? The court. Yeah. Mr. J. So it's a completely separate issue. I just need to know what they're seeking to introduce to see if I object, to see if it's complete, see if it's incomplete, and so on and so forth, like we did with the records. Mr. Owens, can we get you to an answer in the morning? The court, when do you anticipate on moving them to evidence? Mr. Owens, I need to talk to, I believe there's a case law that I can recall the client because she was going to testify to something that happened. And I believe that he got mad at her and he rammed his fist through the glass window or something. He got cut. So he had to go to the hospital. The court, okay, hang on. Mr. Owens, the evidence was going to be in those medical records. The court, let me do this. This is going to take a couple minutes for us to figure out. Let's get the jury out of here so we're not wasting their time. And then we can go from there. What was this again? They were trying to get something in that George punched a window. Was admitted for medical stuff. All right. The jury has been dismissed. Let's see what happens. I don't remember this. The court. All right, with regard to the medical records, the court previously today had required by 5 p.m. to address those. Unfortunately, they have not been addressed. It is imperative that the state knows what it is or calling down or redacting, and I understand that you may want to be seeking those into evidence maybe tomorrow. The state needs to be advised as to what is going to be you're seeking to utilize. So where are we in figuring that out? Mr. Owens, can I have a minute with the client? The court, yes, sir. Mr. Judge, or Mr. Owens. Judge, we've had discussions with Ms. Boone, and she claims that every time he went to the hospital, the medical records would show that it was a relation to some type of domestic violence involving her. We've expressed to her that we do not wish to pursue it and introduce those records of George Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that? The defendant, yes. Yes. The court. Okay, ma'am, earlier we had discussed. Anything else you want to add to Mr. Owens? I think that's it, right? So she wants to introduce those medical records, and the defense team is like, nah, let's not go down that road. It seems. Dun, 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 dun. Question. Who is this? I don't know who's asking the question. Objection. Maybe Mr. Beck? Now you're familiar with the fact that there is a special jury instruction that's been recognized by the Florida Supreme Court. Mr. J. Objection. Approach. Hey, go lucky, how are you doing today? At the bench. The court. Legal grounds of the objection? Mr. J. He's not qualified to get into legal objections. And quite frankly, the law is the purview of the court. We don't know whether this special instruction is to be given yet. The court. What are we doing, Mr. Beck? Mr. Beck, just having you indicate that battered woman is identical to battered spouse as indicated in the jury instruction. It's just the same terminology, same issue. The court, I'm hesitant to address jury instructions. Mr. Beck, okay. The court, we haven't had a charging conference. We haven't agreed on the language on 3.6F instruction, and it's going to be very long. I read it yesterday. I'm going to sustain it in part and allow you or to address the battered women and spouse. I think 3.6F was like something about self-defense or something. 3.6F, Florida. Oh, yes. Justifiable use of deadly force. Florida Supreme... Oh, my God. This is 15 pages. I'm not going to read the whole thing, but let's read a portion of it. 3.6F, justifiable use of deadly force. Because there are many defenses applicable to deadly force, self-defense, give only those parts of instructions that are required by the evidence. Deadly force means force likely to cause death or great bodily harm. What? Why is this document all like fucked up looking? Is this like someone's notes or something? Anyways, that's what 3.6F is. The document has a lot of crossouts and other shit, so I don't know. We're not gonna read that. We good. 3.6F. All right, next bench. What do we got here? Ooh, this might be a long one. Question. Now, I want to go back just a second. We talked about the subjective nature of the abused individual's understanding of what's happening. Does this subjective or does experience that they have suffered result in, on occasion, their experience and their anticipation or assuming or imagining a threat that others may not? Answer. Yes, sir. Mr. J. Objection. May we approach? Court. Yes. All right. Yes, sir. Mr. J. Under the case law that I cited, I can't name the case offhand without stopping and reading it, but this is exactly what is not allowed for PTSD. It's not allowed to come in to show why somebody is subjectively making somebody act differently than the ordinary, objectively reasonable person. What this evidence comes in is, like he explained earlier, to show that it's objectively reasonable to do things like leave. I mean, refuse to flee or flee. What's not allowed is, well, I think in Vietnam, I was in Vietnam. Okay, what's not allowed is, well, I think I was in Vietnam and now fireworks scare me. Makes me think it's gunshot and that's why I heard fireworks, I went outside, I shot my gun everywhere. So that's a position that this is legally not relevant under what PTSD battered spouse can be used for. Response. Or garbage cans. Or that. Or garbage cans. Response. Mr. Beck. Your Honor, I'm fine. Essentially, I'm parroting with a deposition that was taken by Dr. Brandon and by the state. So this is deemed to be an appropriate statement. I can move on. All right. Next batch. What do we have here? Question. In this instance, this particular matter regarding the state v. Sarah Boone, were you approached about the possibility of doing an assessment as to Sarah Boone? Mr. J. Objection. Relevance. The court. Approach. At the bench. The court. My understanding is that he's not rendering any other opinions. Mr. Beck. Right. The court. So what does whether or not he was approached? Mr. Beck, I believe the fact that he did not believe that there was an adequate time given the 30 days that were available to do an appropriate assessment of the patient. In this instance, Sarah Boone. So it's going to be utilized by the defense to establish that expert testimony of Dr. Harper should be deemed more reliable than the testimony of somebody who has only appeared one time in a series of tests and has done nothing more. The court. Anything further? Mr. J. I think it's relevant, that he's approached and declined. And then also I'm going to preemptively object to that since the rules only allow my expert to evaluate her once. The court. All right, I'm going to sustain the objection. Not as to the second portion, but, as to the first. The fact that he asked and couldn't do it within 30 days isn't relevant to any opinion that he's offering. Mr. Owens. Wait, why is Mr. Owens here? Mr. Owens. He's allowed to express what is necessary for him in his own professional opinion. To express an opinion, what he would need, what data he would need, what assessment, how many times, how much he would need before he could give his professional opinion. I think he can testify about that. I would need several sessions with a client. Mr. Owens is funny. The court. But that's not the question that's being asked. The question that's being asked right now is you were approached to serve as an expert and opine specifically as it relates to Ms. Boone. I mean, that's my takeaway from the question. Mr. Beck. I can rephrase the question. The court. So, I mean, if you want to go to that way, that's a different kitty. That's not what before me is right now. Is different kitty, is that like a Florida phrase, term, or something like that? I've never heard that phrase being used ever. When I think of kitty, I think of like the meow sense, Mr. Beck. I'll rephrase the question. The court. Okay. The objection is sustained. Mr. J. I would object under local administrative order that there's only supposed to be one lawyer per witness, and now I'm combating two lawyers. That's right. I was like, why is Mr. Owens up in here? The court. So, I mean, general rules is it's one voice. So whoever's going to be directing that witness, I need to hear for evidentiary response moving forward. Mr. Beck. That's fine. Thank you. The court. Okay. I'm going to sustain the objection, but you can rephrase it. The court. Judge, Mr. Owens. Judge, The court. Mr. Owens, I can't. This is Mr. Beck's witness. Mr. Owens, I understand, but Mr. Owens, this is Mr. Beck's witness. Thank you. Oh, Mr. Owens got shut down. All right, what's next here? Question. I understand your answers today. I'm not saying that they were different the other day, but I do understand that you say it's very important to do a comprehensive evaluation to get a full picture of what is going on in the perceived battered spouse's mind. Correct. Mr. Beck, Your Honor, may we approach? Yes, at the bench. Legal grounds of the objection? Your Honor, I object on the grounds that this is a very area that the state objected to for us going into. I want to ask whether or not the court's opinion of whether or not they've, in fact, opened the door as to the nature of the type of work that he would do and his inability to do it in this case because he was not afforded the time or the opportunity. So I think the state has opened the door. The response, Mr. J. I'm not going anywhere near asking him why he didn't do it. He went into great detail about why it's important to assess the credibility of all the evidence. The court, didn't you talk about the collateral sources in 911 calls and witness statements? Mr. Beck, in a general context, not a specific context, as the state is attempting to do here, and because they are essentially positing these questions in a hypothetical phrase, they, I believe, have opined the door for have opined. Let me start over. Because they are essentially positing these questions in a hypothetical phrase, say, I believe, have opened the door for being able to describe that this individual was contacted and identified, that he could, gets cut off, the court. That's not my takeaway from the state's question. The state's question was, you want to have a comprehensive review? Is that what he talked about? Is what he talked about in direct? Mr. Beck, okay, I just want to ask the question whether or not he could accomplish that review in the time that was afforded to him, and why did he not? The court. As to opening the door, I don't see it because he specifically testified on direct as to what one would be looking for as for rendering an opinion. And certainly that's fodder for cross-examination. Mr. Beck, sure. The court. Now, I'm not going to say it right now and foreclose the opening the door. Let's see where Mr. J's questions go. And I do find it fair game for cross-examination. Which expert is this? Is this Brennan or is this Brennan? I see some Dunkin' Donuts in here. Cross-examination, Dr. I think it's Dr. Brennan, maybe. I think it's Dr. Brennan. All right, next. Sip of water first. All right, y'all. We are at page 1,700 out of 2,500. We are moving along. All right, where are we at now? Mr. Owens, Mr. Lane. Oh, is this Billy Lane? Billy Lane. Billy Lane is the investigator. Okay, Billy Lane. I don't know what's happening. Okay. The court. Just 1 second, sir. I'm waiting for Mr. Owens to return. Mr. Henderson. Judge, may we approach for a moment? The court. Without Mr. Owens? Mr. Henderson. Yes, Your Honor. The court. Sure. Mr. Owens. Can we approach the bench? Oh, he is here after all. Yes, sir. Mr. Henderson asks. At the bench. The court. Hang on. We'll wait for the rest of your team. Mr. Owens, I just called. Can I do this first? Yes, sir. I just called Dr. Harper. She didn't answer the phone, but sometimes I communicate with her by text. I'm just going to text her. I don't know if she's, they made her last night. The hotel room, the Hilton is split into two different types of the room, like a home to home and then the Hilton. They put her on the more expensive one. Ooh, who put her on the more expensive one? Oh no, JC doesn't cover that. Oh no, who paid for it then? They put her in the expensive room. JAC doesn't cover that, so she had to move this morning to the other one. So I don't know what the status is, but I'm going to text her. The court, just text her and tell her to be here at 1:30. Mr. Anderson? Yes, sir. Damn, I wonder if Mr. Owens had to cover the cost of her staying at the more expensive one, or if she had to pay for it. How did they deal with that? Mr. Anderson? Yes, sir. Mr. Anderson? Yes, Judge, I know you stated that 3.6F. I'm also going to be setting 3.6G. Okay, so 3.6F was justifiable use of deadly force. Is 3.6G justifiable use of non-deadly force? I think. 3.6G. Florida. It is justifiable use of non-deadly force. Haha. Okay, I remembered correctly. All right. So they're going to put that instruction in. Whatever instruction you want, please send, says the court. Next. Is this going to be... Oh, I think, is this the neighbor that testifies? Did she ever act uppity? Mr. J, objection, relevance, overruled. Mr. Beck, did she ever treat you in an uppity manner? What do you mean, sir? Did she ever look down on you as a person? Oh, no. Question. Did she ever treat you with disrespect? No. Mr. J, Judge, I'm going to object. This is character evidence. The court. Sustained. Mr. Beck, may I approach on this, Your Honor? The court. Yes. At the bench. Yes, sir. Mr. Beck, that was in direct response to the state having requested of Dr. Brennan as to whether or not there were signs of grandiosity that was presented by, by the hypothetical individual during the course of her life or any other circumstances. I'm refuting any sense the state may have left the jury with that Sarah Boone is grandiose or narcissistic. The court. Response. Mr. J, Judge, it's completely inappropriate to have been asked how she treated Miss Walker. What the doctor said clearly during testimony was that somebody can be very nice in one situation and be very different in a different situation. Yes, and I think that's exactly how Sarah Boone was. Sarah Boone would be very nice to people when she got what she wanted. The moment you didn't benefit, the moment she didn't benefit from you, from the friendship, or the moment that she knew you were turning against her, yeah, she probably was really mean to you, you know? Sarah Boone. Okay, what the doctor said clearly during testimony was that somebody can be very nice in one situation, be very different in a different situation, so it doesn't provide any relevance as to the relationship between Sarah Boone and Mr. Torres, which is what the state's evidence is about. The court. What's your response to that? Mr. Beck, well, I think that's not what his testimony was. His testimony was as part of the corroborative process of evaluating or assessing an individual. You had to look at their interaction with other individuals. The court, unless the objection has morphed, I believe the state's objection is character. So that response goes to more relevancy as to why, but what's your response to character? Mr. Beck, well, one, character has been called into question by the state in the cross-examination of the state's witness. This has been called into question as a result of the cross-examination of Dr. Brennan. The character of the character of this witness, or the character of this opportunity. Did I skip a line? The character of this witness or the character of the opportunity has been called into question, and this is an opportunity for the defense to refute the presumption by describing or at least giving the jury some sense of what kind of individual they are about to judge. The court. Anything else? Mr. Beck. No, Your Honor. Mr. J. That's a misstatement of how the evidence works. They're called an expert witness. They're the ones that opened the door to Ms. Boone's mental health. They're attributing her actions on February 23rd, 2020 to a stress disorder. And what experts have to say, have to consider in evaluating the credibility of the person in this case. The patient, client, relaying information to them are things that Dr. Brennan testified to and what Dr. Harper will testify to. Whether they're consuming alcohol, whether they have narcissistic personality disorder. So what's relevant is what Dr. Harper's perception is of the evidence that she reviewed. And that evidence is going to be largely based on 8 different meetings with Ms. Boone. So how Ms. Boone goes out in the world and interacts with Ms. Walker and anybody else isn't relevant because that's not something Dr. Harper considered. The court. Anything else, sir? Mr. Beck. No, Your Honor, I think our argument has been made. The court. Okay. I'm going to sustain the objection both as to character and to the extent that it's not being offered to show action and conformity therewith. I don't find that it's relevant. In open court, the objection is sustained. What else we got here? I think still an expert testifying in the stand. And did you consider Ms. Boone's upbringing and forming any opinions? Answer, I did. Can you tell us a little bit about that? Answer, yes. So her history, I found it pertinent that she was raised with, I think this might be Dr. Harper now, Dr. Julie Harper. Objection, conduit 704, approach at the bench. Response, Mr. Owens. I'm sorry, the court. She can't be a Mr. J. Conduit. The court. Gateway to inadmissible hearsay. I think, do you remember with the Amber Heard stuff, how she wanted to have her therapist notes admitted? And basically the therapist notes just relayed what Amber Heard said, what maybe happened to her by Johnny Depp. And I think that might be similar because those therapist notes were not admitted. And I remember after the trial, Elaine and Amber were like, well, there was so much evidence that wasn't admitted. You know, if the evidence was admitted and the jury saw it, then they would have believed Amber. And it's like, it was not admitted because it was like all hearsay. It was all like the therapy note stuff. So I think it might be similar, like conduit. You're using another person to get your hearsay in. Okay. Response, I'm sorry. She can't be a conduit, gateway to an admissible hearsay in terms of the court. Anything that Ms. Boone has said to her, that question pertains to Mr. Owens. In terms of what her father passed away when she was in high school, the court, and if she's going to be eliciting statements are provided by the defendant to her, it's admissible hearsay. Mr. Owens, what about materials that she may have been provided in writing? What about that? Records and whatnot. The court, that's not pending before me right now. Right now, my understanding is that she's going to be testifying to specific statements that Ms. Boone has made, and 90.704 prohibits that. So the objection is sustained. I'll put that in my notes right now. 90.704. Florida statutes. Did I find it? Basis opinion testimony by experts. Florida. The facts or data upon which an expert bases an opinion or inference may be perceived by or made known to the expert at the time before the trial. If the facts or data are type reasonably relied upon experts in a subject to support the opinion expressed, the facts or data need not to be admissible in evidence. Facts or data that are otherwise inadmissible may not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion is substantially outweighs their prejudicial effect. All right. So the court says, nope, inadmissible. Move on. What's next? What did Ms. Boone, what has she been diagnosed with prior to getting involved? Mr. J, objection, 704. Oh, did I already read this? Nope. This is a different one. Okay. Approach, Mr. Owens. I didn't realize that was an objectable issue that she'd been previously diagnosed. I thought that was going to come out either. I thought it was going to come with Dr. Brandon, but I thought for sure it was going to come with Dr. Warner and some of the opinions that she expressed, because I know we took a deposition and she said, Dr. Warner said, yeah, I believe the previous diagnosis that she suffers from anxiety or some anxiety disorder. So I thought the experts, and of course they want to form their own opinions, but they are likely to rely on the history of other experts. The court, sure, Mr. Owens. So that was the reason for asking the question. I didn't know it was inappropriate to ask. The court, if you're asking her to rely or testify specifically to something that's inadmissible as to prior diagnosis, 704 prohibits that from happening. Mr. Owens, I understand. The court, and that's what I'm going to take the state's objection to be. Mr. J, yes, it's appropriate for exploration on cross-examination. Inadmissible evidence can certainly come in if it's relied upon by the expert during cross-examination. And it's certainly, I think an expert forensic psychologist or psychiatrist would testify. It hasn't happened here yet, but I understand that it could, so I'm not objecting. But this is the sort of thing that they're going to rely on. Like, I'm a psychologist. Yeah, it's within the course of my practice. Normally rely on other psychologists' diagnosis. The court, we just can't say what those diagnoses are. Mr. J, well, let's admit it to evidence already. And my understanding is that they're not doing it. Hey, Sheena, how are you doing today? How's it going? A handful of pages, but I still haven't been provided them. But it's going to come out in cross. It's just, I think it's under 90.704, which we just read, by the way. And according to Professor Erdhard, pages 954, 955 in the 2024 edition, and that's just for me to bring out. The court, he's correct. It's Mr. Owens. I've got the 23 edition, Judge. I don't have the 24. Time for you to get an update. The court says, but there's been no statutory change. So technically the edition that you have, Mr. Owens, should be the same. All right, judge says, but there has been no statutory change to the 90.704 statute in some time. Mr. J is correct. That's on cross-examination. He's allowed to explore the basis of the opinion and go into those out-of-court statements. You, as the proponent of the opinion, unless you have established the inverse 403 test, it's not admissible. Mr. Owens, I've been educated. All right, good job, Mr. Owens. He's been edumacated. All right, question. Is this Mr. Owens still, I think? Do some people with the syndrome dissociate? Objection. Relevance. Approach at the bench. Yes, sir. Mr. J. We're at about 3 or 4 things where we're just going to ask about people in general. My understanding of discovery is that none of these apply to the defendant. And if it does, that should probably be the question. The court. Does disassociation apply to Miss Boone? Because if I understand correctly, that's what we're talking about. Mr. Owens. Dissociation is battered women. They develop a defense mechanism of being able to psychologically detach from their body during a traumatic experience. The court went to overrule the objection. All right, let it in. The objection to relevance is overruled. Question. Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting. Mr. J. Judge, I'm going to object to relevance at this point. Approach. Yes, sir. Mr. J. Again, we're going into things that aren't even in evidence. There's no biting alleged. If he wants to ask hypotheticals about things that are in evidence, then that's acceptable. But again, we've been down this road for a few minutes now, and they're not being asked in the form of hypothetical, and there's no evidence in this case thus far that said these, like body dissociation or anything that she said. Response? Mr. Owens. Judge, she's testifying as an expert in the field of post-traumatic stress tied to the subset of battered spouse syndrome, what people will experience, and there's been testimony from Sarah Boone about what she all experienced. The court, I don't recall biting. Mr. Owens, I don't think there's any of that either, but I'm just asking questions about generally what do you look for and what do you find? The court, the question that was asked was specific things, kicking, fighting, biting. Mr. Owens, Yeah, that's a general question. That's not specific to Sarah Boone. I didn't ask if Sarah Boone had been bit. I don't know if she's been burned. I know she's been choked. I know she's been punched. I know she's been kicked. And I know she's been hit. Okay, anything further, Mr. J? Mr. J, I don't know. These things need to be asked in the form of a hypothetical, and they need to be based on facts and evidence. The court. Okay, I'm going to find that it's irrelevant. Oh, that it's relevant. What's your response to the improper form of question? Mr. Owens. I don't know what he means by that. Improper form. I can ask, are these acts that are committed by the abusive partner that are common to the court? If you want to ask, what are those acts? That may be acceptable. Mr. Owens. I don't think it's leading for me to ask. Is hitting common? The court. I would agree with that. Mr. Owens. I'll break it down. The court. I'm going to allow you to ask, re-ask and revisit that in another way. All right. So, I think the judge is so patient. He's even helping, attorneys sometimes with how they can ask their questions, or if they're getting a little confused with the objections, stuff like that. Hello, Squirrels. How are you doing today? How are you, Sheena? How is everyone? All right. We are moving on through page 1,900 out of 2,500. Moving on through. All right. Question. Who is this? I don't know who this is. You did interview Brian Boone, correct? Answer. I did not. You did not interview their child in common, correct? Answer. No. Oh, maybe the therapist, though. And you did review the phone text messages extracted from her device, correct? Answer. No, I did not. Question. Did you review any records from the jail? Answer. No. Question. And, gets cut off. Mr. Owens, Judge, maybe approach at the bench. Mr. Owens. He's asked in a way to try to impeach her, and that's something that she should have looked at. She didn't do. We have an issue about that. We had an issue about that. Hold on, let me just reread this whole fucking thing. He asked that in a way to try to impeach her, and that's something that she should have looked at that she didn't do. And we had an issue about that. So I don't think it's improper for him to ask that question. Response? I'm not following. You neither. I'm not following either. Okay, the court. Is your objection as to the lack of review of Orange County jail records or jail records generally, using that terminology, or is an objection as to what she did not review? I still am reading today. How's it going? Hello. Mr. Owens, I think he was implying first, what all did she review? And then he went into you didn't consider this. And when he goes into the jail records, he says records, but really it was jail medical records that we had that issue on. I don't remember if you remembered earlier. The court, when you're referring to Mr. Owens, excuse me, the court, this is the question directed to Mr. J. Mr. J, when you're referring to the jail records, are you referring to anything with regard to Ms. Boone's jail records? Mr. J, yes. The court, because I have concerns about that. I know she elicited that she's been incarcerated, but I'm trying to avoid any prejudice with regard to that. Mr. J, right. I'm just asking if she's reviewed any treatment records, but Ms. Boone is the one who had said that. The court, I know that, but it's specific as to Orange County jail medical records. Mr. J, I can be specific. The court, okay, let's be specific with regard, sir, to your objection regarding Mr. J inquiring of these things. You can take up redirect if whether or not she needs to look at these things. Mr. Owens, didn't we have an issue where we agreed not to pursue the medical records? I thought we were attempting to get them, and the defense, I think, finally got them and was given them right before we were about to pick the grand. Let me just start over. Didn't we have an issue with where we agreed not to pursue the medical records? I thought we were attempting to get them, and the defense, I think, finally got them or was given them right before we were about to pick the jury. And Mr. J complained that it was so late in the game that he was going to have to take time to review all the records over the weekend during his private, personal time. And then ask, I think, maybe to reduce them down. I can't remember. The court, there were 382 pages. This looks like it's like item 6 of the defendant's Fifth Amendment reciprocal discovery exhibit list. Certified medical records from the Orange County Jail, not yet received by the defense. The objection was filed. My notes reflect that 382 pages were provided on October 17th to the state, and I think we had cuts off. Mr. J, that would have been after jury selection. The court, I think it was during. Mr. Oren, oh, it was during? The court, it was during. I don't know that we had finalized because I think it was delivered to them that morning on USB drive, potentially on the 17th, because that was last Thursday. Mr. Owens, it was starting to all blend together. The court. My only notes are that there's something about an intake screen on page 135 through 138. Mr. J, so we had discussed what particular pages they might be seeking to introduce. The court, they were looking to introduce. Mr. J, what I'm asking now is, did she rely upon records that are routinely relied upon by experts in her field, which would include diagnosis? The court, I totally get that. Mr. Owens. And that's the whole reason that I wanted the records, is that I wanted her to review them so this very question would not be asked. You didn't review the records. You should have done that. That's why we got the information as soon as we could. We got it from the jail. It was during jury selection, which is 4 days. I think it was on third day. We hadn't sworn the jury yet. We got them immediately. We gave it to them, and he complained because there's so many pages. He wanted them pared down. Eventually, we had agreed to stipulate that we wouldn't, gets cut off, the court use them, but that was for the purpose of admitting them into evidence. Mr. Owens. I know, but now he's trying to use them against me, and I was doing him a favor. Mr. J, I had reviewed all the records. What we're discussing was what was going to be admitted into evidence. The court, correct. I agree with Mr. J. Mr. Owens, I'm just trying to be a colleague, and now he's using it against me. The court, but the discovery, the exhibit list was solely as to what was going to be sought to be entered into evidence at that time, whether it was you, the whole kitty of everything that may be admitted. I agree with you that Mr. J was, had an issue with 382 pages. Let's take the time, frame out of it, that there were 382 pages, and the issue was calling it down. The only note I have is an intake screen from pages 135 through 138. I don't have any other, but I recall the defense at the time, after discussing, had abandoned attempting to move those into evidence. Whether or not she reviewed them or not, I think is fair game for cross-examination. Mr. Owens, wasn't there some talk about that, about whether she could review those? Because I was going to send them to her. You remember, Judge, I was going to send them to her and you made a ruling. So I said, I'm going to stop sending them to her. And I think you showed an email or showed you a text message that I had sent it to her. It's on my phone, where I said, do not review, in bold capital letters, do not review the medical records. The court, if you want to go back and look at your phone and see if you could do that, I just can't remember. Do not or consider the jail medical records of Sarah Boone. That was October 17th at 1:06 p.m. Kuya says, feels great. I'm lying in bed, free to go wherever I like, eat what food I buy. But Sarah Boone, regretting every day, hating life in jail, reflecting how hard she messed up. Imagine going through what a life sentence. Yes. And then probably sleeping on beds that are uncomfortable. Like Donna, did you follow the Donna Adelson case? Donna Adelson, older woman complaining about jail conditions. I can imagine jail being comfortable when you're in your 70s, 80s, even when you're younger, like me. But yeah, when you're older, that's a tough one. And I think Donna said she suffers from sciatica or something too. You need some special mattress, some exercise. Oof, oof, oof. Uncomfortable. All right. The court says, here's what I'm going to do. I'm going to, I'll give an opportunity to go back and confirm what it is that she has relied on, so you're not ending it at a weird point. I'll leave that to your discretion, but I'll sustain the objection with regards to Orange County jail records specifically. All right. I'm going to get up and use the bathroom really quick. I will be right back, guys. Get up, stretch. Don't get a UTI. Unless you're a guy, of course, because I hear guys aren't really prone to getting a UTI. Sorry, I'm just continuing my UTI comment. It's like a thin mattress. The worst part, she can't sleep peacefully. She's sleeping with a murderer. She's watching her bag. They can smuggle knives in jail out of bowling for the rest of her life. Damn, feels good to be a free man. Maybe you should write her a letter and remind her of that. All right, where are we at, guys? Where are we at? Oh, 1,900. Moving along. Okay. Objection. Who is objection? Okay, I think Mr. Owens is objecting. All right, Mr. Owens is funny. Question. In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer. I based my opinion on the information that I had. Certainly, if there's any more information, my opinion would be subject to change. Question. What was your opinion? Answer. My opinion is that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail. Question, and specifically talking about Mr. Owens. Judge, can we approach the bench? I think this might be Dr. Warner who's testifying right now, who is an expert for the state. Remember, we had issues with Dr. Warner's testimony because if she had a change of opinion about something, or if she had more opinions about a certain topic, she was supposed to alert Mr. Owens, and she didn't do that. So that was a huge issue. And then they had to do, Mr. Owens had to do like a impromptu deposition outside the jury's presence. All right. The court, what's the legal objection, sir? Mr. Owens, I don't know if it's a legal objection, but Dr. Warner evaluated Sarah Boone at the Orange County Jail on October 2nd. 2 days later, on October 4th, I took her deposition on several of the issues, and she said, I have not formed an opinion as to whether or not she suffers from this or that. A couple of them, she said she was convinced that she suffered from alcohol abuse syndrome, but on issues like post-traumatic stress, issues like battered spouse syndrome, I think it's a couple more issues, she said. I would need more time to reflect. Since I just saw her 2 days ago, I would need more time to review my notes. She said it would probably be a couple more hours that I would need to spend on it. And then I said, well, can we agree between the lawyers that if she forms any opinions, that the defense will be notified? I was not notified. The court, okay. Mr. Owens, that she formed this opinion. The court, Mr. J. Mr. J. My expected answer from her is that based on what Sarah Boone said about the events, that battered spouse syndrome is inapplicable because Mr. Torres and her were laughing, and that it was her who decided to get angry and would not let him out of the suitcase. That's all I'm trying to establish with her. Mr. Owens, I understand, but we had an agreement that if she changed her opinions that you would let me know, and we could agree that I could retake a deposition. The court, give me a moment. Mr. Owens, it was an agreement, Judge. I'll show. The court, that's what I'm pulling up right now. Mr. Owens, it's mentioned on several pages. It's more than the court. Do you have specific pages in the transcript that address this agreement? Mr. Owens, it starts at line 38. Court page 38. Mr. Owens, well, I start to ask her on line 17 that she responds on line 21, but it goes on for several pages after that. The court, this pertains to adjustment disorder, if I'm reviewing it correctly. Mr. Owens, well, it keeps going on, Judge. Like I said, several pages. The court. I know, I'm on 41 right now, specifically page 41, line 15. This is from Dr. Warner. So she's saying, I'm assuming that's Boone. She's has generalized anxiety disorder. And I'm saying I want to review it more to see if I think it's more of an adjustment disorder to being in the correctional setting right now and the stressors that she's under right now as opposed to general anxiety disorder. Mr. J on line 22 then states, okay, so on this topic, if something new comes up, then we can address it. But if other topics disposed wrong, then I suggest we move on. Moving to 42, line 1, Mr. Owens, I agree. Dr. Warner, just let the state attorney know. I know that you may, we are short on time if you do review your notes over the weekend and whatnot and formulate any other opinions. Just let the state attorney know and we'll address it. Witness, absolutely. Here's the thing. When the witness testified, it seemed like she was just really fucking busy, and that her coming out here to testify and her doing the Sarah Boone case, it seemed like she just absolutely had almost no time in her hands and she just really rushed it. This is the state's witness, by the way. Honestly, I think she just forgot, and I think she just rushed everything. And then that's why she didn't alert Mr. Owens about her new or her new opinions about Sarah Boone. I think she was just very busy and overworked. Because I think she was talking about how her real job, she works there I don't know, maybe even 7 days or something like that. But I think she was just really busy. And I did feel bad for Mr. Owens when this happened. Mr. J, I think it's page 46. I think the problem is that she didn't answer the question that I'm trying to ask her on page 46. Court, line 1, Mr. Owens, just need to read 46. The court, okay, let me read 46. Give me a second. I mean, unless I'm missing something, it's lines 13 through 15. She identifies that as, unless I misunderstood the question or answer, it's in the depot. Mr. Owens, I would have to look through my notes to see if she fully met the criteria. The court, but the answer is no. Question line 13, page 46. But you don't believe that she suffers from post-traumatic stress disorder in your opinion? No. Mr. Owens, look at line 19. The court, I'd have to go through my notes. I back through my notes to see if she fully met the criteria. I'm sorry, hit the wrong button. Line 17. Can you explain why you don't think she suffers from? No, I don't think I didn't say that one way or another. I would have to look back through my notes for that. Is that something you may in the future give an opinion on about after some time reflecting with your notes? I may. Okay. Mr. Owens, 25. The court, okay. That's something you will let me know if that changes. Yes, okay. Mr. Owens, and then the court, just for the record, that's 46, lines 25 through 47, lines 1 through 2, the deposition of Dr. Warner. Mr. Owens, should it go all the way through several? The court. Okay, well, the issue right now is the PTSD, is the opinion on PTSD. So what I don't hear is a legal objection. Mr. Owens, we had agreed. I don't know if I can find the right page, but we had agreed to retake a short deposition. Maybe if you give me some time, I could find where Mr. J said, I will agree to a short deposition if her opinion changes between now and the time of the trial. And I relied on that because she would not be pinned down. If you'll give me a few minutes, I can find it. Do you want to let the jury out? The court. I think we're going to have to at this point of time. Mr. J, do you have anything to add just for my own edification at this time? Mr. J. Again, Judge, what I'm trying to establish with this witness, regardless of whether Miss Boone had PTSD, A, B, C, D, or XYZ, fucking Mr. J, or anything else, that it doesn't matter based on what Miss Boone specifically told her about the incident. That's all I'm trying to get out. The answers went divergent from the question. I don't think I'm violating an agreement because her opinion had not changed. I was only able to speak to her for 2 minutes yesterday and just asked her about the specifics of does this apply given what she said about the event. And that's not something that's new from the deposition. The court. All right, let's remove the jury for a moment. Thank you. So again, this is where we had some major sidebars, some major breaks, and the jury was excused or brought back in, and then they were excused again because we had issues with Dr. Warner, her testimony, and how she formulated a new opinion and did not tell Mr. Owens that she was supposed to reach out to the state and then let them know, and then also reach out to the defense, and that didn't happen. Mr. J, state would move to strike the last response as non-responsive. Approach the court. Any response? Mr. Owens, I disagree. I think that's the one where we talked about I'm going to be able to use to impeach her with her statements that she made in the deposition versus the statements she made today. If I'm referring to the correct response, which response is it? Mr. J, the last question I asked in front of the jury, she gave a non-responsive question. Oh, I think that's when they brought the jury back in and then they continued the questioning. The court. What's your opinion? My opinion was that she did not give enough information to diagnose her with PTSD at the time of evaluating her at the jail. Mr. J. Well, the question before that is what's relevant? The court. What else did you rely on? Mr. J. No. I basically asked the same thing that my proffered questioning was asking. Then she gave this non-responsive answer that caused all of this. The court. I'm going to overrule your request. The question was, what was your opinion? And the answer to that last question was, what was your opinion? All right. I think at this point, he was basically objecting to his own witness, or strike the last response was not responsive for his own witness. I'm pretty sure they are going to excuse the jury again soon. Yeah, I think right around here. All right, question by Mr. J. And what particular part of her statements about that incident is that? Answer. The whole part where she's describing the part about playing hiding and seek and that they were having a good time. They were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All that is inconsistent. All of that isn't consistent with her having a feeling that she's at imminent risk or imminent fear, that there was an imminent risk of harm. Mr. Owens. Judge, I'm going to object. Can we approach the bench? At the bench, Mr. Court, the court. Legal grounds of the objection. Mr. Owens, Judge, I don't object to her expressing. The court. What are the legal grounds of your objection? You just said I object. What are the legal grounds? Mr. Owens. Is it improper response to a question in the ultimate issue, the fact of being asked by the prosecutor? It's an improper answer to the ultimate issue. The fact is for the jury, not for her. The court. Response? Mr. J. This is no different than the expert saying insanity applies or doesn't apply. It's their expert opinion on what portion of the law and it's permissible, on that portion of the law and it's permissible. Mr. Owens, I do not believe that. The court, just because, even assuming that the answer embraces an ultimate issue, that doesn't mean it's objectable. It doesn't mean she's committed homicide. I'm not saying she committed homicide. I'm not saying she's negligent. It's not saying that she's punitive. It didn't go to any one of those specific elements. Mr. Owens, she's not expressing a medical opinion. She's not expressing a scientific opinion. She's expressing an opinion as to whether or not her behavior, her conduct, her statements constitute an imminent threat. That is a province of the jury. The court. She didn't say that. Mr. Owens. Yes, she did. The court, or Mr. J. This is the exact same thing as a doctor saying somebody didn't appreciate the legal consequences or did. This is an interaction at the intersection of the law and psychiatry when this testimony comes in and it's not objectionable. Mr. Owens. Think about what she said. She's also been telling the jury that there was not an imminent threat. That's the question for. Gets cut off. The court. Essentially telling the jury and telling the jury are two different things. What specifically did she say, Mr. J? Mr. Owens. She mentioned, we can't have the court reporter read it back, but it's a critical issue, Judge, about the ultimate issue of the fact about whether this psychiatrist, based on history, my client gave to her 4.5 years after this event, whether or not I believe as an expert, no, the defense doesn't apply because she was not perceiving an imminent threat. The court, but the question didn't ask about a defense unless I missed something. Mr. J, I agree. That's just absolutely no different than if an expert. Hold on, let's go back to what she said. She said this. She said that they were playing hide and go seek. They were having a good time. They were laughing. He got in the suitcase. She found him. They were enjoying themselves. She zipped him up. They were still laughing, having a good time. All this isn't consistent with her having a feeling that she's at imminent risk or imminent fear that there was an imminent risk of harm, and then she gets cut off. Okay. Hey, Tanika, how are you doing today? Hello, these are juicy. Hello. How are you? Thanks for popping on in. I hear the family court stuff is really interesting. I've not read of any of that stuff yet, though. All right, to the extent Madam Court Reporter reads it again. Oh, I guess, did she read it again? Oops, I should just let her read it again. All right, let's go back. Mr. Owens. She mentioned, I do not, and we can have the court reporter read it back, but it's a critical issue, Judge, about the ultimate issue, the fact of whether the psychiatrist, based on a history my client gave to her 4.5 years ago after this event, whether or not I believe in it as expert, no, that defense doesn't apply because she was not perceiving an imminent threat. The court, but the question didn't ask about a defense unless I missed something. Mr. J, I agree. That's just an absolutely no different than if an expert. Mr. Owens, I think we need to reread the question and reread her answer. This is a critical issue about guilt or innocence that she is expressing. The court, are you able to reread it for me? Mr. Owens, Judge, I'd ask that it be done outside the presence of the jury. The court, to the extent possible, if I have to, Madam Court Reporter, come up here and do that, I will do that. All right, disconnect, members of the jury. Did they ever... I think this was done in open court, right? Open court. Yeah, open court. Okay, they tell the jury to leave. Yeah, how long? Oh my God, this is pretty long. Mr. Owens. Yeah, I remember Mr. Owens was kind of pissed about this because of what Dr. Werner was saying. He's saying that the jury is the one that should be determining whether or not self-defense was justifiable and whether or not Sarah Boone perceived that there was an imminent threat or not. And the court did overrule the objection. Actually, let's just read it. Could we just read it? The court, thank you both for your arguments. The court is going to overrule your objection and find that it's not the ultimate issue of the fact as addressed by 90.703. The court specifically relies on Dinkins v. State 976 as pinpoint 661. In that case, a psychologist testifies in the instant of case in Dinkins. The psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocent. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective and, quote, incapable of consent to intercourse. Although opinions did not go to the ultimate issues in the case, Florida law, expressly provides that an expert opinion may render such opinion. See section 90.703 Florida statute. Mr. Owens is like, see what now? Let me look this shit up. Which provides testimony in the form of the opinion or inference or otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of facts. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled. All right. Mr. Owens is not happy. What's going on here? Madam Court Reporter, I'm just going to have you read the question and answer the jury. Then I have no further questions of the witness. The court, okay, thank you. Mr. Owens, I'm sorry. The court, he's going to have Madam Court Reporter read the question and the answer, and then he's going to have no other questions for this witness. Mr. Owens, I object. Basis, it was asked and answered. The court overruled. There's a pending objection. I'm going to allow the state to re-ask it so it's a clear base on that objection. Judge, it's 11:30. I'm going to be at least an hour for my cross-examination. Jury enters back in. I think they have the Madam Court Reporter ask the question and then reads it back. And then Mr. J says, no further questions. All right, cross-examination. Now, cross-examination was very spicy, I would say, because Dr. Warner... she had I give no fucks about anything when she was doing the cross-examination. When she was being cross-examined by Mr. Owens. Poor Mr. Owens, man. Okay, Mr. Owens. Is this with Dr. Warner still? Possibly, maybe. My Mr. Owens. You said you consider some text messages from Sarah Boone's phone. I reviewed them, correct. Would it be correct to say that those text messages that are not necessarily overly relevant? Mr. J, objection. May we approach? Yes. Yes, sir, Mr. J. This is outside the scope of what she reviewed for her opinion that were expressed today. The opinion she expressed today was based on the evaluation of Ms. Boone. Court response. Mr. Owens, Judge, she considered everything that was given to her. She reviewed that, everything that was given to her before she went to the jail and had interviewed Sarah Boone, so that she had that in her mind when she interviewed her, Sarah Boone. Is he okay? And her opinions are tied to the paperwork that was given to her. That's standard operating procedure of any expert in this field who relies on collateral sources, as well as the assessment made of the patient. The court, any response? Mr. J, may I voir dire the witness then and ask her, did this inform your opinion as what you just expressed your inapplicability? Why is the font dying? What you just expressed about inapplicability of BSS, is that BSS? And PTSD to the facts of this case. I don't know. Something happened with the paper. The court, but it was provided to her, correct? Mr. J, right, but she did not express that she relied on it. The court, yeah, I'll allow you to voir dire the witness. Go ahead. All right. So I think the judge is still not in here. Oh, so not the judge, the jury. Yeah, I think they're still doing the voir dire of Dr. Warner and the jury is not in. All right, let's see. Question, and you're going to express some opinions here today, are you not? Answer, correct. Question, you're going to express some opinions about narcissism? Mr. J, objection, may we approach? The court, yes. We're at the bench right now. Oh, that was Mr. Owens asking the questions. Mr. J, this is outside the scope of direct. I didn't ask her about narcissism or any of the things. If they want to recall my witness, they can, but this is way outside the scope of the cross. The court, response, Mr. Owens. Judge, this is an expert witness. We've given wide latitude to cross-examination. I can't believe you're trying to limit the court, but she didn't offer any opinions on narcissism. So what facts or consequences make it more or less probable? Even if it may be in the deposition, what does it matter for the purposes of today based on what she rendered opinions on? Mr. Owens, I'm allowed to caution her on any opinions that she may have about my client. Just because they specifically only want to ask her about one opinion that she has about the issue does not limit me from asking an expert opinion in psychiatry about any other conditions that she may or may not suffer from as it relates to the ultimate issue that she's expressing and asking the jury to decide on the issue of self-defense, battered spouse syndrome, whether she acted appropriately under the circumstances. The court. Anything further? Mr. J. Judge, the reason that the state went into narcissistic personality traits that Dr. Harper expresses that she has, and the reason we had Dr. Brennan explain all these things was because it was specifically relates to the credibility of the patient or the client informing the doctor, and it goes to the weight and credibility of the opinion that they may render. So what we got into is the alcoholism. That's what we got into the alcoholism with. That's what we got into the narcissism with. And all those things were asked and answered by their experts as to directly relate to the credibility of the historian given that information. So if he wants to impeach his client's statements about having her express that she opines that she had narcissistic personality tendencies, it's on them. But the court, I'm not addressing that. Mr. J, it's not the basis of her opinion. Mr. Owens. Dr. Brennan testified, Dr. Harper testified that it's standard operating procedure to rely on all of those. The court, but that's not the issue. The issue right now is whether it's outside the scope. That opinion was not offered. I'm going to overrule the objection, but I find that it has really limited relevance based on what her opinions were. But I'm going to allow you to proceed on it. Mr. Owens, well, Judge, if I'm not allowed to explore the court, that's not what I said. Her opinions, that's not what I said. What I said was, I'm going to allow you to do it, but she didn't offer those opinions. Mr. Owens, I understand that, and I'm allowed to cross-examine her that she didn't find certain diagnosis. The court. The only issue for me right now is an opinion on narcissism. The state's objection is that it's not being offered. That's not relevant. I'm going to overrule their objection, but just be mindful that they're not offering any of these opinions. Mr. Owens. Well, it goes to the other objection about whether I can go into what other evidence she relied upon in expressing her opinion as it relates to Sarah Boone. She relied upon collateral sources, including, gets cut off, the court. That's not what's in front of me right now. The issue is not in front of me. There's been no objection to that at this point in time. The only objection was to the text messages, and it was not a basis. Mr. Owens, can we go ahead and talk about it? Sure, go ahead. Mr. Owens, well, I think this all started when I was talking about, ask the expert, Dr. Werner, about Sarah being cell phone records, and I believe the state attorney provided her. I'm not sure if it was. I'm pretty sure it was the text messages from the cell phone. And I believe it was testimony from Dr. Werner is going to say, and the reason this comes up is I know they're going to introduce a bunch of text messages. The court, What are you trying to get at? Mr. Owens. Judge, I guess. The court. If you're getting to the basis of her opinion and what was relied upon, you're absolutely allowed to do that. But you have to understand, based on what opinions were elicited during direct and what the courts heard, none of that mattered for the purpose of the opinion she testified for today. If you want to do that, I'm not going to foreclose you from doing that. It's your decision. Mr. Owens. If they're going to be objecting to me asking all the information, all the evidence, I'm going to get into the medical records. The court. I'm going to. Mr. Owens. I'm going to get into the Advent records. The court, if that was the base of your opinion, you're allowed to explore it. That's all I'm saying. Mr. Owens, are you going to be objecting to, Mr. J, the testimony that she gave was outside materials that were absolutely irrelevant to the opinions she gave? Hey, Joe, how are you doing today? How's it going? The court, I understand that. Mr. J, and the court, I understand that. If he wants to explore it, he can explore it. It may not be beneficial. I don't know. Mr. Owens, I need a ruling, Judge, because if you're going to rule that I can explore it, the court, I've already ruled it, sir. I said you can explore it. I said you can. Mr. Owens, okay, but the court, the problem is I don't know what the utility of that is going to be because of the limited scope of the opinions. She didn't rely on anything of that stuff in informing the opinions, and she's done that today. If you want to do that, you can do that. I'm not going to say no. Mr. Owens, okay, his suggestion was, and my thing is, I'm going to get into medical records of Sarah Boone, and I'm going to get into the specific notes about those medical records relating into her Baker Acts. The court, okay, Mr. Owens. If that's going to be objected to, it's because it's not relied upon, then I'm going to need to call Dr. Warner as my own witness, as an advert witness. The court, okay, wait a second here. Okay, did she rely on medical records? Mr. J. She was provided them, but her direct testimony that we all just heard together was it did not inform her opinion that BSS and PTSD, BSS battered spouse syndrome, okay, and PTSD do not apply to the facts of this case. Take a sip break. Oh, my mouth is getting dry. The court, if you're able to tie that, she relied on them somehow, we can address that. It doesn't address any issue of hearsay or 704 issue. Mr. J, well, experts, I mean, just like I did. The court, on cross-examination, you're allowed to go into it. Mr. J, if an expert relies upon what she testified today, she did not rely upon it. So each time he brings up a new piece of evidence, I'm going to voir dire her and ask her if that informed her of what opinion she gave. Mr. Owens, Judge Craddock, yes, sir, yes, sir. Hi, Diane, how are you doing today? Mr. Owens, that's what I'm getting at. Let's not bicker and fight about this. If he's taking a deposition, or if he's taking a position, sorry, my mouse hovering over it. If he's taking a position that he's going to object to everything, but he's not going to if I call her as my own witness and I can treat her as an adverse, the court, no, I don't think it's the same. Mr. Owens, witness, let's do it. The court, it's the same problem. Mr. J, you can't, the court. But he's correct on that. 90.704 prohibits that. You're allowed to do it on cross, but the problem is it's not the basis of her opinion of what was offered today. So 702 tells us what we need to do, how it's relevant for the purposes of her opinion that was provided today. Yeah, I looked at those medical records, but they have nothing to do with opinions I relied on. I opined on today. Mr. Owens, that's not the same issue. The issue is cross-examination and wide latitudes allowed, especially for an expert witness. The court, you're not answering my question. The opinion that was offered was, this is my opinion. BSS and PTSD are not applicable based on what was reported to me. How do the medical records have anything to do with that as a sufficient fact and the data point that she relied upon to render that opinion? That's the first step. Mr. Owens, it's her opinion. I can expose her opinion as not reliable. I can expose that she admits that she suffers from battered spouse syndrome. I can expose her opinion that she suffers from alcohol use syndrome. I can expose her opinion that she suffers from anxiety disorder or adjustment disorder. I can expose her opinion that she meets some criteria for narcissism and she relied on those records in formulating that opinion, as every expert does in the field. I'm granted wide latitude to go into all that to express, to attempt to impeach, to show that she's biased, to show that she's a state's witness and that her only job is try to help the state win their case. Boom. The court, I understand. I'll allow you to proceed, but you're going to take answers as they come because if she keeps saying it had nothing to do with my opinion today, that's what you're going to be stuck with. I don't know what she's going to say, but I mean, the state's opinion was very truncated as to what they're offering for her. Hey, Sean, how are you doing today? I'm doing good. Hello. Oh, you're making some chicken fajitas? Oh, yummy. That sounds good. What kind of, what are you adding to the fajitas? Mr. Owens, And for my position with the state attorney is if you're going to be objecting every time and you're suggesting that I just call her as my own witness, I'm willing to do that just to save some time because I don't want to get into this and spend 10 minutes up here every few seconds. If it would be better, I'll just call her as my own witness. The court. Anything else, Mr. J? Mr. J, just so that we understand the law, you can't get into admissible evidence on direct. The court. I know that. Mr. J, and there's no basis for a Sarah rebuttal case. So basically, they're saying if you call her as your own witness, it's the same thing. There's not going to be a different effect. The court, I'm not addressing Sarah rebuttal at this point in time, but he's correct. 90.704 is going to prohibit her on direct examination from testifying directly to inadmissible evidence. Cross is a different kitty. The rule specifically addresses that. I'm going to allow you to do it, and you can object, Mr. J. And Mr. J, I'll just ask for a voir dire. The court will address it as we go. You may proceed. Objection is overruled. Actually, now I kind of want to know what happens here. Let's read this. Mr. Owens, ma'am, is it fair to say in your evaluation of Sarah Boone on October 2nd, 2024, that you felt the text message you received from the state attorney, objection, beyond the scope, overruled by Mr. Owens, are not relevant to the evaluation of Sarah Boone? Withdrawn. The witness, I wasn't sure at the time I wasn't sure whose phone number it was, in all honesty. We discussed in the deposition. I wasn't sure I had proof of who actually sent the text, who actually had possession of the phone and put the text. Oh, that's right, because Sarah and George were essentially sharing phones, and you can't really tell who was texting. I mean, I feel like you could. I feel like you could tell, which one was Sarah Boone and which one was George. But I think the defense is trying to say that, like, oh, well, you don't know who was doing these text messages. You don't know who was writing these notes because Sarah Boone and George were sort of sharing the phone. Mr. Owens, well, I was there for deposition. Was I not? I appeared on Zoom. Did I not? No, sir. You were present in person. Do we get anywhere? Phone records. We discussed what was on the phone records from Sarah Boone's phone. Answer, yes. Question. Okay. And at the time, you said they are not necessarily overly relevant to your evaluation. Did you say that? Answer. I don't recall specifically. I'm happy to look at it if you turn me to the page. Question. May I approach the witness? You may. I have it. May I have voir dire? Just a moment. Mr. Owens, you got it. I do. Question. Page 14. My question is at line 3. Your answer begins at line 5. Answer. Correct. Question. And do you agree with that? Mr. J. Judge, permission to voir dire based on the court. Let him finish. Mr. Owens, I'm going to ask another question about the text messages, Judge. The court. You just said line 5. Approach at the bench. The court. I asked her to refer to page 14, line 5, and I have a depo in front of me. It says, I was aware of them, but not necessarily overly relevant. But they're not necessarily overly relevant. Mr. Owens, that's correct. The court. So what are we doing? If you're going to ask her to rely on that and ask her about the text messages, you need to give her the opportunity to say, this is what she said. Mr. Owens. All right. Question. Dr. Warner, did that refresh your recollection about the discussion about the text messages in your evaluation? Answer. Yes. Question. And would you agree that they're not necessarily overly relevant to the evaluation of Sarah Boone? Answer. Correct. Question. And you agree that after reviewing all those text messages, there's nothing that struck out to you that caused you to pause and feel like they may have some impact on your evaluation of Sarah Boone? Mr. J, permission to voir dire. Mr. Owens, can she answer the question? The court, have her answer the question first. The witness, I'm not sure what you're referring to in the deposition. Okay, so we're talking about, I don't know, I just kind of want to know what happens here. I don't remember this. Text messages. Page 14, the question's at line 21. Your answer is at line 25. Correct. And I said no. As I said, it made me aware that they had a volatile relationship. Question. But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations? Answer. Correct. And you agree your answer is no? Answer. As I said, it made me aware. That's not my complete answer. Question. Okay. First, you said no. Answer. As I said, it made me aware that they had. Question. Ma'am. Answer. It's not my complete answer. Question. I know, Dr. Warner, but you didn't say no to me. That was your first sentence was no? Answer. It's not my complete answer. Question. I understand. I want to let you answer that, but when I asked you if there's anything in the text messages that caused you to pause and it would be in some way after the impact of that would affect the impact of your evaluation, your answer to me was no? Answer. It's not my complete answer. Question. I understand, but your answer to me is no? Answer. Yes, but that's not my complete answer. Question. Now at the time, Dr. Warner, at the same time, you expressed that they had a volatile relationship. Answer. That's not the totality of my answer either. Question. Okay, I'm going to get into it. Okay. But part of your answer was that they had a volatile relationship. Correct. And this is in relation to the question about the text messages. You agree? Yes. After you said no, you said they had a volatile relationship, that she texted calling him an idiot, a fucking idiot for overdrafting her account. Correct. And in those text messages, there was some reference to domestic violence between the two. Correct. And that demonstrated to you that they had a violent relationship. Correct. And do you not agree that the evidence of a violent, volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome? Judge, I'm going to object. We need to approach. Okay. Yes, sir. Mr. J, I didn't offer an opinion that she suffered from battered spouse syndrome. The court, what's your legal objection? Mr. J, it's outside the scope. The court response, Mr. J, and it's misstating. Mr. Owens, Judge, this is cross-examination of an expert witness. I'm allowed to explore impeachment, bias, prior inconsistent statements, whatever the standard cross-examination. I'm allowed a lot of latitude. Cross-examination is fundamental to defendant's right to a fair trial, especially the court. But what does this have to do anything to do with anything if she's not? Does she render an opinion as to this issue? Mr. J, yes, just earlier outside the presence of the jury, she said my client did suffer from battered spouse syndrome. Mr. J, the state didn't offer that. The court, your objection is outside the scope? Yes. My objection is overruled. Mr. J, and relevance, misstatement. The court, how is it a misstatement of facts? Mr. J, because she had not testified to that in front of the jury. The court, that's fair. Mr. J, I'll ask her. Mr. J, or Mr. Owens, I'll ask her. Mr. J, and we're going to object. He can explore and cross-examine her opinion that she rendered and point out all the things that she should have looked at and didn't, and that's fine. But now what he wants to do is have an imaginary direct examination that I didn't give her. He imagined that I was going to go into all this stuff, and I didn't. This is all going to be outside the scope because she didn't rely on anything for the opinion she expressed except for Ms. Boone's evaluation from October 2nd. The court. Anything else? The judge. Mr. Owens. Judge, I got Earnhardt down in the car. I mean, I don't know if you need to take a break for me to get that, but I don't have that rule. But she expressed several opinions relating to Ms. Boone in her deposition that gets cut off. The court. But just because they're in the deposition doesn't mean it's necessary for trial. We all know this. Mr. Owens, they directly affect my impeachment of her on the opinion that she expressed on direct. I'm going to make those arguments, my cross-examinations are going to be tied to my closing argument in relation to limiting her opinion when she had other opinions that were not disclosed by the state. The court, I'm not going to get into that disclosure or non-disclosure. We've already addressed that. Mr. Owens, no, I'm talking about that he didn't ask her on direct. He limited his direct. The court, that's his choice. Mr. Owens, exactly. I'm allowed to explore all the others and then argue that he didn't explore those issues. He wanted to limit. The court, I'm not going to allow that. That is improper closing argument. That is complete improper closing argument. That is demeaning the credibility of an adversary. You are attacking a person. That's an ad hominem attack. You're not allowed to do that in closing. He didn't do this. It was his choice. He didn't do that. You can't do that. Now, if you want to talk about the opinions that she's offered, that's a different kitty. But I'm not going to allow you to attack Mr. J or you, Mr. Owens, to attack each other in closing arguments. Spoiler alert, I think Mr. Owens does attack the state, and then they have a sidebar about that. Grilling some peppers and some onions. Ooh, yummy. Any jalapenos? I have another batch of the green chili chicken enchiladas that I have to cook. I need to get more tortilla, though. All right. I'm not going to allow you to do that, Mr. J or you, Mr. Owens, to attack each other in closing argument. We are not going to do that. I understand stress is high. I understand tensions are high. We need to bring down the boiling point. But I am not going to allow you to attack each other one way or the other in closing. Mr. Owens, can we have a break? I'd like to go get the Earnhardt. The court, I'm going to allow you to do that. Mr. Owens, I understand, but I'm a little hot right now. I think a break would do us all some good. I feel like if I had a chance to get Earnhardt and review it, I could point to the issue. Obviously, this is a critical issue in this case. The court, I'm not disagreeing with you. All right, 12 o'clock. The court, I'm not disagreeing with you. Mr. Owens, I'm about to blow my top. Mr. Owens needs a break. Good. He needs a break. Let him chill the fuck out. The court, okay. I don't want that to happen. I don't want anyone to blow their tops. Mr. J, anything else? Mr. J, no, sir, just that cross-examination. We understand what cross-examination of an expert entails. If an expert comes in and gives an opinion about A, certainly attack that. But just because I chose not to give her opinions B, C, and D doesn't mean he gets to bring them in and attack them. The court, here's what we're going to do. We're going to go ahead, take a break, and then I'm going to ask the jury to be back here at 1:30 p.m., and then we'll pick up from there. Is there any other argument you're going to make other than outside the scope of relevance with regard to Mr. Owens' opportunity to explore these other opinions? Mr. J, depends on the questions asked. That's fair. Mr. J, But again, if he's going to say, well, text messages or Aspire records or whatever, when the opinion she offered today was not based on it, I'm going to object to the relevance of it. Okay, I got it. Mr. Owens. And Judge, I want to review Earnhardt. I'll further response if something changes. Understood. Okay, thank you very much. All right, so we are going to have a little lunch break before Mr. Owens blows a lid. I actually have never read this part before. I think I accidentally, I must have missed it. All right, well, I'm going to continue to, oops. Let me highlight this. Highlight, please. Highlight everything. All right. That way we have it. All right, next one. Bench time. I don't think this is anything crazy. All right, what about this? I think this is it still Mr. Owens? I think so. Mr. Owens doing his cross of Dr. Warner, possibly. Question. When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder? Answer. It was probably within the next week when I was reviewing all of this, going through all the documents and her interview more thoroughly. Question. Dr. Werner, did you agree that you did not notify me? The judge. Mr. J. Judge, may we approach? Yes. Yes, sir. Mr. J. I didn't ask her for any of these opinions, so I don't see the relevance. The court. What are we doing, Mr. Owens? Mr. J. And it's improper. The questions. Mr. Owens. Oh, sorry. Mr. J says it's improper. The questions. Mr. Owens. She's making an opinion here today in court. The court. Then there's another way to ask it. Mr. Owens. When she told me, the court. There's another way to ask it. Hey, this is the first time you've rendered this opinion. You did not render this opinion in your deposition. That's the other way of asking, other than saying, hey, we agreed and you lied, and anything along those lines. Mr. Owens is charged up. Okay, he's fired up right now. That's why, Judge. Mr. Owens. She said some things in depositions that she would notify me or notify the state attorney if she had changed in any of those opinions. She failed to do that, Judge. The court. There's no change. There is no change. We've been over this. Mr. Owens. Judge, at that time, let me get through the transcript. Oh, let me get the transcript. The court. Mr. Owens, I don't need to reread the deposition transcript. You provided to me. I'm familiar with the portions that you're relying on. Mr. J. Judge, it's improper for him to ask about opinions that I did not, then again, cross-examine her on. Had I wanted to get her opinions on these things, I would have sent her all these records that we have. I didn't want to delay the trial when she gave me her opinion that battered spouse syndrome didn't matter in this case, so I foregoed giving her any additional records that I could get valid opinions, and now she's being allowed to ask about these opinions and then cross-examining them on her. It's improper. The court. The question before the court is improper. That's impending right now. I find it improper. That's not discovery issue. That was remedied and something that the jury needs not to worry about. If you want to ask for questions about the formulation of that opinion and when it was provided, that it wasn't provided at depot, and today may be the first time that it's been provided to you, fine. But we're not going to get into there was a promise and it gets complicated. I'm not going to do that. The objection is sustained. Poor Mr. Owens. All right, what do we got here? Who is maybe Mr. Owens still? And you would agree that's a subset of post-traumatic stress disorder? Answer, yes. And you would agree that Lenore Walker first developed the theory of post-traumatic stress syndrome? Yes. And I think at the time of the deposition, you weren't sure that you knew of Lenore Walker? I don't recall that. All right, look at page 54. Objection, collateral, excuse me, approach. Mr. J, it's collateral impeachment. It's not a material issue. The court, what is this, her knowledge, and what line specifically on 54? Mr. Owens, it starts on 54. I start the question at 23. The court, where is the impeachment at? Mr. Owens, you see on 54, I think Lenore Walker is the one who first developed. The court, she responds, I'm not sure. Mr. Owens, she responds, I'm not sure. I got therapeutic trustees, which is the authority to trustees on battered spouse syndrome. The court, right now, we're looking at impeachment. What's the impeachment? Mr. Owens. Well, the court. What's the contradiction? Mr. Owens. Is that she didn't even recognize who's the authoritative person in the field of battered spouse syndrome, which Dr. Michael Brennan recognized, and I think she spoke of it. I know he spoke of her in his testimony. I think Dr. Harper mentioned Lenore Walker's 3-step cycle for battered spouse syndrome, and she was not even sure who Lenore Walker was. The court. Okay, what's the impeachment? Mr. Owens. The impeachment is, I'm going to ask if she recognizes this as authoritative trustees. They spoke on it. She wasn't even sure who Lenore Walker was. The court. What if sustained that as collateral? Mr. J. While we're here, what's becoming obvious to me is that when we started asking about alcohol abuse disorder and narcissistic traits and all the things the state did not get her to opine on, this is essentially like him calling his own witness to impeach, and that's improper impeachment under the evidence code. I can't call a witness just to impeach the witness in front of the jury. This is what he's doing on these new topics. He's bringing these topics up that the state didn't, and they're impeaching her on them, and it's improper. Mr. Owens, judge, the court. I disagree with impeachment on them, but I'm going to agree with you that this is a collateral matter, and I'm going to sustain the objection. What else we got here? Are we near... Who's smoking a cigarette? Oh, this is a video? Oh, this is a video with Sarah Boone. Maybe it's a body cam video or something. All right, guys, we're in page 2,200 territory. Are we getting to closing arguments, maybe, possibly? Let's see. We are reading text messages on George's phone, possibly. Mom, George, to owner, I'm coming over with the handle. I was helping Pop all day cut grass. Owner to Mom, George, yay you. Getting in the shower, then out. Bye-bye. Mom, George to owner. Mr. Owens, Judge, can we approach the bench? Yes. Yes, sir. Mr. Owens, this is the problem that I tried to address in the beginning about having someone else reading these text messages. He's changing his tone during the reading the text, which is what I thought he would probably try to do. I object. The court. Anything further? Mr. Owens. No, sir. The court. Overruled. I could have sworn when he read the text messages it was very monotonous. I think it was so monotonous that I decided to read the text messages myself, if I remember correctly. Text messages. Oh, this was like a long one. Okay. Oh, is this when they're reading the Sarah Boone notes? Okay, so guys, this is like a little bit, well, not even a little bit. This is pretty fucking unhinged, but I think we wanted it for context, maybe. This is Sarah Boone writing the notes, I think, in her notes, and I think she's like kind of writing it to George, maybe. Going on through the rest of page 43, page 44, including page 44, dirty, cheat, enjoy your porn, jerking yourself off secretly so your parents don't see and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who well and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all well worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow, now you really are. You're despicable. Next text is XOXO from Mo to owner. Page 50, 6/28/2019, 10:55, 47 p.m. From owner to Mo. Just know, I can do so much more damage than all of you put together. Know that. Oh my gosh. Whenever I hear the phrase just know or know that, I just automatically think of Sarah Boone now. Woo! Going to page 51. Try me. Oh gosh, she's so cringe. Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner, no metadata, but from Janice. Sorry, it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but he was quite bummed out that he overslept. But I was okay. Told him, no problem. Just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered. So I have no idea where he is or what he's doing. What happened last night? He had a black eye. He said it was new because I asked him and he told him to put makeup on it. He said he'd taken care of it. Did you two get into it again? He acted like when I told him he had a black eye, at first he didn't know what I was talking about. I guess he kind of just blacked out. You can text me back if you want. 11:30 p.m., 30 seconds from owner to Mom George. Janice just called me looking for George and she's pissed. Congrats. Page 82, 8/21, August 21st, 2019. From George to owner. I love you, my friend, my love, my queen, my everything. Your Honor, that concludes everything I'm going to publish to the jury on this exhibit. Mr. Owens. Judge, can we approach the bench? The court. Yes. Yes, sir. Mr. Owens. Judge, I understand they introduced that exhibit as a copy of the exhibit, which was 111 pages, but we didn't know which ones he was going to cherry pick and read to the jury, so there needs to be some kind of instruction that explains what just happened. I'm exhibiting something like out of 108 pages that there were exhibits. The prosecutor elected to read those sections to the jury now. These text messages are not all the ones on the phone. Those with the highlighted have been selected to be read by the state attorney. Something like that. And also, Sarah Boone and George Torres shared that phone, and some of the messages may be George. I don't know, man. Do you guys think some of those messages were George? Those hateful, spiteful messages? Could have been George. Love the blame game here. The court. I'm a little hesitant. You're covering the microphone. I'm a little hesitant to give the second part that George and Miss Boone shared the phone. That's me commenting on evidence. I'm not allowed to do that. Mr. Owens, you agree they shared the phone? Mr. J, I think you're more than welcome to point that out in closing. I think I said it in opening. The court, I'm disinclined to do that. I'm not allowed to comment on the evidence. Mr. Owens, okay. Then I think one of the other instructions we're going to have to ask is that the prosecutor jump pages. He went from 4,324, which is July 26th of 2019. Then he jumped to page 4,336 to August 19th of 2019 as he was reading that. So the jury, I believe, needs to understand all of that. The court, I'm disinclined to identify specific pages. Again, I think it's me commenting on the evidence. I'm not on board with something along the lines of with Exhibit 21, just a 108 pages, or it's everything that's included, including those pictures and everything else, right? Mr. J, it's the videos and the movies as well, which some were published. The court, which was published yesterday. Okay, so what if I had the something along the lines of the state has concluded their presentation of State's Exhibit 21. It's not inconclusive. It's not inclusive with everything. The state identified certain portions for you, and that the entire exhibit will go back to you in deliberation room for your review. Oh my God, they had the entire exhibit. I wonder if they wait. How long did it take to deliberate again? Was it under 5 hours? I wonder if some of those time was just them being nosy and just reading some of the exhibits. I don't know. I feel like I might be like, oh, I want to see this. I want to read this. Damn, they had the whole entire exhibit to go back with them. Mr. Owens, I trust your judgment. Mr. J, it sounds verbatim as to what I said at the beginning. If it needs to be coming from the court, I don't have a problem with that. The court, I don't have a problem saying that. I'll do my best to remember what I just said. Mr. Owens, you want to write it down? The court, I want to write it down because I kind of just spit that off the top of my dome. Mr. Owens, and of course, Sarah Boone wanted me to let the judge know that the context of all the read text messages by the state were not read in their entirety. I think she meant maybe the thread of the text messages. This changes the understanding by not knowing the whole message. I don't know. Them having the whole message doesn't really change the meaning. I know context is everything, but I don't know if it helps her. The state only selected what they wanted you to hear, that it was not complete. Also, she objected by his tone, by the way he was changing, it changed the understanding. Some were not read properly in the light of manner as they were meant to be sent by the defendant. The cadence, she's saying that he had special cadence between each other and the other way they talked to each other, and he missed by his tone. He was misrepresenting their cadence by him reading those to the jury. The court, I don't see any heightened change in Mr. J's tone as he read the messages. They were read in a flat manner. There's no emphasis on certain words or another. Thought it was read in a benign tone as best as possible. As to the cadence, the conversation between Ms. Boone and Mr. Torres, I can't speak to that. I don't know that anybody spoke to that other than Ms. Boone. I don't find any issues with the way in which the state delivered the reading of the instructions. The tone was flat. It was benign. There was no raising and lowering of pitch to add any drama to the text messages that were highlighted. So I'm going to overrule the objection. Mr. Owens, okay. My only suggestion when the jury's out is you can go ahead and announce that so Sarah Boone can hear it. The court, I don't have a problem with that. I'm fine with that. Oh man, Mr. Owens is like, yeah, tell my client. Okay, I tried telling my client that she didn't believe me, so that's why I want you to read it out loud. I feel like that's what happened, you know? I feel like Mr. Owens is letting Sarah Boone being the boss a little bit instead of just dealing with your client on your own. All right, that's fine. Let me go back with the instruction. What about something along the lines of members of the jury, the state showed you portions of State's Exhibit 21. It's not the entire exhibit. The entire exhibit will be sent back to you on the laptop for its review during deliberation. Is that acceptable? Perfect. Yes. Anything else we need to address? No, sir. Anything else, state? No, sir. Thank you. All right. I think we're getting close to a closing argument, maybe. Possibly. What is this? Are we talking about Mr. Mr. Owens and his exhibits that he printed at the FedEx Kinko? Okay, so, okay. I remember Mr. Owens was maybe possibly trying to blow a lid about this one. So they are doing closing arguments right now, and they are playing the video on for the jury to listen. Sarah, fuck you. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't fucking breathe, babe. Seriously. Yeah, that's what you do when you choke me. Sarah. Mr. Owens, can you ask the jury to go out? Video pause. At the bench. Mr. Owens, please ask the jury to go out. She's weeping and crying. I'm going to ask for a mistrial. She's not allowed. If the jury's not allowed to go out. The court. Hang on, Mr. Owens. Hang on. Mr. Cacciatore. I don't think we need to do that. Just give the opportunity to go over there and ask her to step out of the courtroom. Mr. Owens, hell no. No, she's bailing over there crying, sobbing. Mr. Cacciatore, she's leaving. Mr. Owens, Judge, please let the jury go out. Mr. Cacciatore, she's leaving. The court, go out. Mr. Cacciatore, they don't need to. Mr. Owens, this is highly prejudicial to my client for that being happening in front of the jury. The court, she's gone. Mr. Owens, thank you. The court, anything else, Mr. Owens? Mr. Owens, yeah, I don't know what else to do other than instruction, some kind of a curative instruction, but I have to think about it. The court, well, think about it. Tell me what you want me to do. Mr. Owens, can we have a minute? Can we have the jury go out for a minute? The court, no, I don't want to do that. Mr. Cacciatore, no, not. The court, not in the middle right now. Mr. Cacciatore, I mean, Mr. Owens, I should have asked, Judge. It's probably my fault because I should have said, because a lot of the times the judge would say, anybody in the audience is known to have an adverse reaction, yay, nay, sad, glad, whatever the case. If you're going to show some kind of physical or audible reaction, you need to leave the courtroom right now. The court, but I don't want to bring any more attention to it than is necessary to this point in time, so I'm hesitant to give that instruction to highlight it. I don't know if the jury saw it. I don't want to point it out that somebody has left out or something along the lines. Mr. Owens, let's just leave it at the load. The court. Okay, all right, as you wish. So they're playing the video, and of course, George's mom has like a visible reaction to it. I don't know if the jury saw or heard it, but apparently she had like a, reaction, of course, because she's a mom, and that's probably so devastating for her to hear her son's voice, again. And she left the courtroom. But I remember Mr. Owens was like pissed. Like he was trying to ask for a mistrial, and it was huffing and puffing a bit, All right. What do we got next? Are we in closing yet? Who is this? I think we're in closing argument by the state. He couldn't exert anything, ladies and gentlemen. He couldn't. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his... Gets cut off. Mr. Owens. Judge, I object. The court approach at the bench. Mr. Owens. That's a misstatement of facts. He could not exert his arm out of the suitcase. The court. It's argument. It's closing argument. Mr. Owens. That's a misstatement of facts. The only testimony in this case was that he reached his hand out of the suitcase. The court. Correct. Mr. Owens. There's no testimony or evidence that he did not. The court. Okay, hang on. Response? Mr. Cacciatore. An arm is not in hand, and your client gave several versions of events to include only fingers. So, the court. He's correct. There is different versions reported by the experts and by Miss Boone. Mr. Cacciatore. But there has been zero testimony that an arm was ever protruded from the suitcase. The court. Response? If anything else? Mr. Owens. We all heard the testimony that his hand came out of the suitcase. The court. Right. Mr. Cacciatore. A hand is not an arm. The court. I agree. I think it's closing argument. That's a fact in the record for him to argue it. So your objection is overruled. Man, closing arguments, I felt so bad for Mr. Owens because I felt like he was really tired, overworked, and I think he just messily put the closing arguments together, or maybe he was just really nervous. But his closing argument was kind of a disappointment. But I think he was just like really tired, overworked, and he was just like not prepared at all. It was kind of a letdown. All right. Who is doing closing arguments now? I think it's Mr. Owens. I'm going to take my time. I've got some notes. I'm not the most organized person in the world. Yep, we know that, Mr. Owens. I've got some exhibits here that we're going to show you, and then we've got a couple videos at the end, okay? And we're going to try our best to help you to make the right decision, okay? But yeah, Milton is a small town. Mr. J, objection, relevance. The court, overruled. Mr. Owens, tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando. Mr. J, judge, relevance. Mr. Owens, judge, I'm allowed to introduce. The court, I'm going to give you a little more time for intro, but then we need to get into it. Mr. Owens, I'm going to get into it, but I wanted to say it's a small town. Good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. Mr. J, objection, improper argument. Mr. Owens, approach. The court, I'm a little worried about I didn't know what to expect. Mr. Owens, it's just that we've been treated very well, very hospitable by the people in the street, by the people in the court system. The court, okay. Mr. Owens, I'm just simply trying to explain to them that we're from a small town. We didn't know what to expect here. We got plenty and pleasantly surprised with how we're treated. The court, Mr. J, anything else? It's completely irrelevant. The court, I'm going to overrule. I'm going to give him the opportunity, but I don't want to belabor this for too long, okay? Thank you. You know, I kind of want to go through all the objections because I remember Mr. Owens was getting so annoyed with Mr. J objecting. He was so annoyed. He kept giving Mr. J like death stares, and then like I remember he like started praying in his hands. It was kind of cute. It reminded me of Tifa, or who was the one that does the praying shit in Final Fantasy? Oh, Aerith. He was like praying to God that he wouldn't blow a lid at Mr. J. Maybe, I don't know. Please God, let me get through this. Let me get through this shit. This is wild. Oh man, it's funny. I can't wait to see the sidebar stuff with Lori Vallow. Sidebar, Lori Vallow, transcripts released, please. I'm sure maybe the transcripts will be released when they start doing the appeal stuff, and then the appeal attorney, if there is going to be an appeal attorney, maybe we'll request for the court transcripts. I would love to hear the sidebars with Lori Vallow. Guys, let me know when that comes out. All right. Mr. Owens, all I wanted to say is just since we've been here, we've been treated with respect and hospitality, and just like we've been at home, and we appreciate that. Now, I'm going to be doing some reading, and then I'm going to be doing some talking, but ultimately, this is just about a justifiable use of force. That is a legal defense in Florida. As we, citizens, the law was designed to protect us from defending ourselves, to protect us from such potential attack. And you are the only ones in this case because Sarah Boone was arrested, and that's going to be looked at critically and objectively. Objectively, not like the state attorney. Damn! Objection, improper argument, overruled. Mr. Owens, objectively. And the law in Florida gives you all the power and authority to do that. The state attorney can make that decision. They can make the decision. They can't try to influence you. We're going to be talking about some of the things they did here in this trial and some of the things they said. Judge, objection. May we approach? Yes, at the bench. Judge. Yes, sir. Mr. J, I believe the court made it very clear that they weren't going to go into ad hominem attacks, and that is exactly what we're starting. The court, where are we going, Mr. Owens? Mr. Owens. Judge, I can make comments on the state and the state's case and what evidence they presented. That is argument. The court, I agree with you, but we're not going to have a personal attacks on individual persons. That's my only point. Mr. Owens, Judge, he objects to everything. Everything he objects to. Everything. The court, I can't speak to Mr. J and his objections, okay? Mr. Owens, he thinks he knows it all and he objects to everything. This is my chance. Oh my God, he's so pissed at Mr. J at this point. Oh, can I reread this again? This is so funny. The court says, I agree with you. We're not going to go to have attacks on individual persons. That's my only point. Mr. Owens, Judge, he objects to everything. Everything he objects to. Everything. The court, I can't speak to Mr. J and his objections, okay? Mr. Owens, he thinks he knows it all and objects to everything. This is my chance. The court, and stop that right there. That's an ad hominem attack, and that he objects to everything. He knows everything. If that's where you're going in your closing argument. Mr. Owens, I'm not going there, Judge. The court, but you're doing it right now. You're doing it right now. The court, or Mr. Owens, it's outside the presence of the jury. The court, I understand that, so I want to make sure that the line in the sand is unremarkably clear or remarkably clear. We're not going to have any ad hominem attacks. If you want to attack the state's position, their evidence that they provided and what they provided, and it's insufficient for their burden of proof, I 100% agree with you. 100% fair game. But if I hear Mr. J or Mr. Cacciatore in an argument, we're going to have a talk. Mr. J, and Judge, I'm going to move to strike that state is trying to improperly influence you. The arguments have to be about the evidence and the inferences about them. He's attacking the other party. Mr. Owens, Judge, what I'm saying is we're going to show the state's evidence, what they presented. The court, what I overruled objection on was the state was trying to influence you. Now, I let it slide because let me see where you go with it. I'm not going to sustain Mr. J's objection at this time, but let's not attack a person. You want to attack a position, you want to attack evidence, go ahead. We're not going to be attacking persons. Mr. Owens, okay. The court, thank you. The court, you may proceed. Objection is overruled. Mr. Owens, thank you, Judge. They've got their side, their position. We've got our side. So we're going to talk about that. But we're going to talk about justifiable use of deadly force and non-deadly force. But either way, you rule, however you rule, it still justifies her behavior. And the result is not guilty. Now, I don't think there's anybody. Objection, improper argument, overruled. Mr. J, may we approach? Yes. The court, is it with the I don't believe there's anybody language? Mr. J, he's interjecting his personal views. Mr. Owens, I haven't finished Mr. J, excuse me. The court, hang on. Mr. J, The proper way to make these arguments is I submit. But what he's doing now is saying I believe, and he's going to interject his personal beliefs on the evidence. That's impermissible. The court. What is it you're going to say, Mr. Owens? Mr. Owens, I forget now. The court. Okay, let's be careful with interjecting own personal beliefs. Similarly, we can't use the golden rule. We can't ask the jurors to put themselves in a position of the party. Be careful with interjecting your personal beliefs. Mr. Owens. Okay. The court. You may proceed. I wonder how many objections there are because everybody's getting so pissed. Hi, Lauren. How are you doing today? Hi, Corey. Hey, Chad. How's it going? Hello. Woo. Okay. I think we were very close to being done, maybe. Oh, we got a little bit more. Okay. Who is this? Mr. Owens. All right. Let's see what Mr. Owens has to say. Abraham Moreno knew George Torres from Philly, okay? They were friends. They would talk about either the complex or if Moreno went to Hall's Ace Hardware or Ace Hardware or whatever the fuck it's called. We didn't say that. Do they not have Ace Hardware? No, do they not have it on the East Coast, actually? Is Ace Hardware on the East Coast or in Florida? Okay, let me start over. Abraham Moreno knew George Torres from Philly, okay? They were friends. They would talk either at the complex or if Moreno went to Hall's Ace Hardware or Ace Hardware, whatever it's called. Well, whatever the state attorney notifies. Mr. J. Judge, I'm going to object to reading from things that's not into evidence. Approach. Mr. J. Judge, this is completely improper. All he has to say is that a man has two different statements at two different times. It's completely the court. I don't believe the statement that Mr. Moreno came into evidence. I know there was questions about the statement, Mr. J. But Judge, we concede he made an inconsistent statement. What's inappropriate is talking about our obligations to turn that statement over and going through all of this, just make the argument that he's uncredible witness because he did not make consistent statements. It does not have to come back to say the state attorney has this. He's reading from his phone. It's not an evidence. Mr. Owens, I didn't read from my phone. I was reviewing the notes. But Judge, what happened was they're getting ready for trial and they call Moreno in and there's some discussion about an accident. And then there's all of a sudden he remembers additional evidence 4.5 years later. Additional statements that my client made 4.5 years later. The court. Okay. Mr. Owens. So they notified us. They notified us. The court, or Mr. J. He's attacking the state. The court. I'm not going to let you read from a statement that's not in evidence. That's the primary objection. Mr. Owens. He's stating Tony Henderson brought it out, but he stated that in September he changed his testimony. And now he's saying, Mr. J, if he can lower his voice, Mr. Owens. Now he's saying Sarah Boone said I was teaching him a lesson. The court. I have that. Yeah. Mr. Owens. And things got out of hand. The court. Mr. Owens. And then I fell asleep. The court. I have that in my notes. Correct. Mr. Owens. And that's his new statement. The court. Okay. Then highlight those two things. I'm not going to let you read from the statement. Mr. Owens. Okay. The court, because the statement is not in evidence. Mr. Owens, but I've got it on my phone, so it's refreshing my memory. I thought he wasn't reading from his phone. The court, that's fine. I just don't want you to reading from. My concern was there's an issue with impeaching or potentially trying to impeach Detective Kepsel with an interview statement at some point in time that never came into evidence. I just want to be mindful that I'm not going to be relying on things and arguing things that are not in evidence in closing. That's my only point. I'm going to ask you to politely to stop putting onuses on the state and the state had influenced you on this or the state did this. If you want to attack the evidence, that's fine, but we're getting dangerously close again to the ad hominem attack thing that we've spoken about previously. Mr. Owens. Judge, it wasn't until he met with the state attorney preparing for the trial that all of a sudden he had a change in testimony implicating Sarah Boone. The court. There was a phone call with the ASA on about September 23rd. That information was addressed at that point in time. Mr. J, there's jury instruction that says it's permissible for the court. You can't read that into that. I agree. You read it into the jury already. If you want to make the argument that the testimony was different and that it goes to credibility, and you're absolutely free to do so, but I'm not going to let you read stuff to the jury that's not in evidence. I'm just asking you to politely be mindful of the ad hominem attacks with regards to the state. That's it. Mr. Owen says, Judge, I don't know how. They chose to put on the case. I have a fundamental right to attack their evidence and what? The court. But you're not. You're not attacking the evidence. You're attacking the person. Mr. J, you're attacking the state's choice to do this. The court. The state's evidence shows this. The state's witness says this. The state has called, testified to this, and that was impeached or contradicted later. That's all acceptable. But the state does this, the state did this, the state did this in a different argument. It's just this. It's a different argument. Mr. Owens, Judge, number one, the state got up there and claimed that George Torres is battered spouse. The court, they pose a question to the jury as to whether or not you have to question whether George Torres, that's different than a statement. Mr. Owens, all right, I just believe that you can attack the way the state attorney is presenting their case and the evidence that they're presenting. The court, attack the evidence. Do not attack the state attorney. That's the end of that. Thank you. You got this, Mr. Owens. Did he end up getting it? Hello? Bench? Why is it not highlighting? Oh, oops, wrong one. Oh, we're at the bench again. Okay. Now what? Mr. Owens, again. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know that you saw that 2-hour video. At some point during the 2-hour video, they start talking about some of the violence, and they go, we know. They already had checked in with the neighbors or whatever. They knew. The neighbors knew. The police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even though all the abuse. Judge, I want to make a comment about a couple of things that was said by the prosecutor in opening statement. The court, you may proceed. Mr. Owens, okay. The prosecutor in opening statement, when he was talking about George Torres passing away, had started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented to that, Mr. J. Judge, may we approach? Oh, the chicken feet did turn out good. Yum. Did you make them spicy? Some jalapenos in there? All right, they are approaching right now. What do we have here? Yes, sir. Mr. J. It's fair to point out things that didn't come out into evidence, but the evidence in this case was she said that he deserved to be put in that position to have to listen to her and to feel her pain of being choked and cheated on. That's what Mr. Owens. Mr. J. Excuse me, sir. The court. Hang on. Mr. J. That is what we stated in opening statements in regards to putting him in the suitcase. We have never taken the position that she intended to kill him. The argument is made repeatedly during defense for whatever reason that she didn't intend to kill him. And that is a jury the instruction. We don't have to prove that. It's improper. He's attacking me now. That argument is ad hominem. The court. What are the other 3 things that you wanted to address that were in opening other than what's already been addressed? Mr. Owens. He was implying George Torres died and he pointed to my client in opening and said, she thinks he deserved it. Or worse to that effect, he deserved it. The court. I think the evidence, it could be taken in such a way based on the videos and other statements that were made that the jury may be able to make that decision. Mr. Owens. The other comment being made about all the batteries, the violence that George Torres had committed on Sarah Boone is he referred to as a bunch of violent nonsense. That's his quote. The court. I recall it. Mr. J. This isn't Mr. Owens. I'm entitled to comment on closing statements and what prosecutors made in opening. Response, Mr. J. It's one thing to say the evidence doesn't support that, but it's another thing just to attack the prosecutor. The court. So again, I'm going to allow you to address the issue. Let's just frame it with, this is what was said in the opening. This is why that's not accurate. Or here, look at the pictures again, whatever you want to do, but let's just avoid the attack individually. Just say this is what was said in opening. Do you remember how Judge Kranick had the students around him to watch the court case? Do you think they got to listen to the sidebars and see how patient he is in dealing with Mr. Owens? Hi, Subtubescent. Hello, how are you doing today? Hey, Corgi, what's up? Hi, Lord. Or no, I said hi to Lauren already. This judge is the most patient judge ever. I know. And that's why he's the perfect teaching judge. Perfect teaching judge, man. All right. Mr. J. Approximately how much longer? We're just circling back and forth to what Dr. Harper said 3 or 4 times. And it's the court. You've been at this don't worry about it. You've been about this for about an hour and a half, ballparking at Mr. Owens. I mean, I'm not like him. I'm kind of just scatterbrained, so I'm not going to bounce. Mr. Owens, he's so honest. He's such an honest guy. That's true, Mr. Owens. You were all over the place, but I don't think it's because he's scattered brain. I think it's just because he's disorganized. But he has admitted that he's disorganized. Oh God, he's so funny. Mr. J is like very formal, you know, goes by the rules, very like concrete, A, B, C, D, you know. Mr. Owens is kind of like just, yeah, he all over the place. But I think it's because Mr. Owens didn't have time to prepare for his closing arguments. And I don't know, maybe he like tried winging it or something. Mr. Owens, I mean, I'm not like him. I'm kind of like scatterbrained. I'm not going to be bouncing around. So I'm going to be bouncing around. He makes me laugh so much. Okay. Mr. Owens. I mean, I'm not like him. I'm kind of scatterbrained. So I'm going to bounce around a little bit. But I mean, I'm trying to save her life, Judge. The court, I know. I understand. I'm not putting a cap on you. Just ballpark for me where you're at. Mr. Owens, I'll try. I feel like I'm finished. I'm getting close, but I don't want to miss anything. The court, I understand. Mr. Owens, I'm afraid I'm going to miss something that one juror may think is important. The court, I understand. So I think Mr. Owens just kind of like I said, I think he's just winging it. I don't think he had time to prepare. Oh boy. The court, are you going to have, you know, since we're up here, are you going to have someone else jump into the breach, or are you just going to conclude yourself? Mr. Owens, Tony Henderson said, James, why don't you do your deal? And then if I feel like I need to add something, I don't think he's planning on to unless he thinks I missed something. The court, okay. So the case law seems to be that it should be based on old common law. I'm looking at case law back in, 1930s. There should be one lawyer in closing. Now, that was based on a statute in common law and Wharton's trustees, I think, on criminal procedure. So I'll defer to you if you want to switch over. It's a matter of discretion. And just for the record, I'm referring to Tyndall decision in Tyndall v. State, Florida Supreme Court, May 17th, 1930, 128, So it's a matter of discretion. But, Mr. Owens, only one lawyer can? The court, but it should be, and it should also cite to Landrum v. State, Florida Supreme Court, March 1, 1920, which says when there are two or more counsel, the order in which they are to speak is determined by the court, citing the Wharton's trustees on criminal procedure. If you want to, I think it's odd, but I'll leave you to your discretion if you want to do it. Mr. Owens, we weren't planning on doing it. It's just when we found out that we were using two lawyers to make the argument. That's when I said it. Tony, they're using two. I wasn't planning on it. The court, with that, I'll let you point out I do remember the nonsense comment or words to that effect. I'll just let you point that out, but let's just avoid particulars. Just that was said in the opening. Here's why it doesn't work. You may proceed, sir. All right. Do you think he does better? Or do you think he continues yapping it away? All right. We have another bench. Now, what do we have? This is the state. Okay. The state. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal, because she's the one that said cheating to be meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were. She believed that he was cheating on them with her. And apparently she is too with some guy named Ben. Man, anyone know Ben out there? I wonder if Ben is like, whew, I dodged a bullet. Or I wonder if she's just exaggerating her relationship with this Ben guy just to try to make George jealous. When I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real, but they just don't apply to this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed. Mr. Owens, Judge, I object. Ben dodged a suitcase. True, John. Good one. All right, the court approach bench. The court. Basis of your objection, Mr. Owens. They don't apply in this case. We've had two witnesses that testified that she's a battered spouse, his own expert, the court. But he's arguing the law that was just placed up on there. And specifically, Mr. Owens, it was before that. He was talking about the injuries. The court, no. The statement right now was to self-defense not being applicable due to his argument of her being the initial aggressor. And that's what the jury instruction, Mr. Owens. He was just saying that the injuries did not apply to this case. The court, that's not what he just said. Mr. Owens, that's what I heard, Judge. He was talking about the interview. He was talking about the court. He talked about the violence and the prior violence, and it doesn't apply to self-defense jury instruction. Mr. Owens, it doesn't apply to this case, is what he said. Mr. J, that's correct under law. Mr. Owens, to this case, battered spouse applies to this case. For him to say that for his own expert said, his own witness expert said that she suffered from battered spouse, the court, I'm going to defer to the jury instruction to what Mr. J was just making reference to, which he outlined. And it identified if you're the aggressor, that is the analysis that you have to go through. Sarah, hey, how are you doing today? Hello. How's it going? How are you, Sarah? I hope the snowstorm, or not snowstorm, but I hope the severe storm was not too severe. Mr. J, Mr. Owens, I mean, he just talking about the violence that he claimed was nonsense, just got through talking about the stab, that it was a minor surgery. The court, and it got infected, right, and all of those things. Mr. Owens, but all of that is not part of the case. The court, that's not what he said. He didn't say that it was part of the case. That's not what he said. Mr. Owens, can we have it back? The court, he just said it was part of the case. Mr. J, Judge, the court, yes. Mr. J, could you make a ruling? The court, objection is overruled. Thank you. Thank you. Mr. Owens, Judge, can I ask about time? Because he was trying to restrict my time. He said I've been rambling for about an hour and a half or however long it was. How long have they been? Dude, Mr. Owen hates Mr. J at this point. Oh my God. Owens is like, fuck Mr. J. I hate this guy. The court, approximately 15, 16 minutes. Mr. Owens, all right. What's their total time? The court, I think Mr. Cacciatore was about an hour and 20 and you were Mr. J. I'm wrapping it up. The court, a little bit shy of 2 hours. Objection is overruled. Oh, man. Oh, what's going on here? In closing, let me remind you that it's important to follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. If you do not like the laws that must be applied, you must use them. For more than 2 centuries, we lived by the Constitution and the laws. No juror has a right to violate the rules we all share. Oh, it's by the judge. Could the parties approach at the bench? The court, any objections to the instructions as given? Mr. J, no additions, corrections, deletions, and if you have any grammatical strike-throughs, we don't object. The court, okay, thank you. Mr. Owens, other than that previously mentioned in the conference, the court understood. Thank you. Thank you all very much. Oh, no, now the jury's going to go deliberate. Bye, jury. And there we are. We are done. The jury has deliberated. We have sent them away. And it came back with guilty verdict. Hi, Sherry. How are you doing today? Glad to be here. I need to break from watching the Karen Reed case. Boone case, although wild its own, is way much clearer than Mass v. Reed. Hello, everyone. Hi. Sherry, how are you? Well, we are done. We got through 2,529 pages. Not that we read all those pages, but we got through the sidebars that I thought were very interesting. And again, if you guys missed the beginning of the transcript, we filmed it about a week and a half ago, and I'll probably have it all in one video. So it covers the jury voir dire, why the jury was dismissed. It talks about Brian Boone and how initially they were worried about Brian Boone's testimony and how they brought up that Brian Boone wasn't paying alimony to Sarah Boone or child support, but it's because Sarah Boone was incarcerated for like 4.5 years. And then we got into a lot of the sidebar stuff with them, the reason why they dismissed the woman that was in the gallery because she was not taking it seriously and she was just like shouting random shit. So they nicely asked her to leave and, let her go watch the live stream instead. And then there's just a lot of back and forth, in the sidebars. But most importantly, at the very end of the trial, we are starting to get a very, very strong sense that Mr. Owens just fucking hates Mr. J, the state prosecutor. At that point, Mr. Owens is like, you know what? I can't contain it anymore, Judge. He thinks he's a know-it-all. He's just objecting to everything. Oh, all right, guys. So, how long was today's stream? Let's see. Time. We are keeping an eye on the Karen Reed case. I think I stopped at the Cellbrite expert, but I'll probably listen to the rest of it on my own. But other non-Karen Reed streams, I do want to go over the new stuff that's been revealed in Brian Koberger's case, and then some stuff with Donna Adelson as well. So far, we've had a Corey Richins, who's supposed to have her trial right now, that got moved. We don't know when the new trial date is, but then also for Donna Adelson, her trial has also been delayed. So everything has just been delayed, and I kept telling all my family that I can't go on vacation because I'm like, no, there's court stuff here, there's court stuff there, I can't do vacations, and I'm not going to be free until maybe the end of this year because it was supposed to be Karen Reed and then Corey Richins going to Donna Adelson and then going into Koberger in autumn season. So I was like, I won't be free until, I don't know, maybe the beginning of next year. But now the calendar has just opened up. Now the calendar is opened up because all the trials are getting pushed and stuff. So sometimes it just be like that. But yeah, I do want to do a separate stream covering some of the Koberger documents. I already have my notes on that, but I don't know if I should do a stream or if I should just make a video. For for Donna Adelson, I do want to do a stream, I think. So keep an eye on that, guys. We'll definitely do some, other case coverage. Look forward to it. Now, as for the Karen Reed case, my understanding is that they are going to be doing full days this week. But again, the definition of full days is going to 4 o'clock. So I don't know if I'm going to try to do my streams during the Karen Reed stuff or what. I don't know. We'll see. We'll see. But for those of you guys who missed the Sarah Boone sidebar transcript, I am going to make a video out of this, or you can just watch the live stream if you want, whichever you prefer. I think for the live streams, I just read most of it. It wasn't a lot of like side conversations or anything like that. It was just a very focused, pointed live stream reading of the sidebars. But I'm going to go rest my throat because I can feel my throat getting a little bit scratchy, a little bit itchy. All right, guys. Hey, Pookie. Hello. Butterfly Down Under. Yeah, you guys are talking like the mushroom case, but it's not live stream from my understanding, right? So how are you guys getting the reports? Is it just like reporters that are tweeting about it or something? Whew, that sounds like a wild one. But you guys feel free to keep me updated. Feel free to join the Discord if you guys like. Have your notifications on for YouTube. Put it to all notifications. And then, if you guys really want to make sure you get your notifications, join the Discord. Discord never fails in giving you notifications. Feel free to join. We do have a true crime section. And I'm going to go rest my throat. Okay, my throat is a little bit. All right, guys. I hope you guys have a good one. Take care. Oh, are you talking about the podcast? They were talking about a podcast earlier. All right, guys. Have a good one. Take care. It was, I'll let you guys know if there's any more update. Oh, hold on a second. I do want to read some court stuff with Alexi Treviso. I mean, they're old though, but I still thought they were very interesting. I do think the Alexi Treviso case is very interesting because of the roles of the healthcare providers and whether or not, how much they should be involved in a case with law enforcement. I don't know. Because as you guys know, in the Alexi Treviso case, the statements that she made to law enforcement during that time, and the body cam and some other stuff, the trial judge has decided to exclude those as part of the state's evidence. And right now, the state is trying to combat that by going to the Supreme Court. So we haven't really heard too much about the Alexi Treviso case because the Supreme Court is kind of dealing it out. But I do want to read some of the arguments. There are some, arguments in support of Alexi Treviso, and then the state has responded to that. So I kind of want to read that to you guys. I think it'll be kind of interesting, and to learn a little bit more about law enforcement and the medical setting, and then learn about all that HIPAA stuff. And yeah, I think it'll be kind of interesting. So I will definitely do a live stream on that, and yeah, we'll definitely do that. All right, guys. Well, thank you so much for hanging out. You guys take care. I'm gonna go drink some hot water and go gurgle some fucking I don't know, some honey or something. I'll see you guys later.